Chief Justice, Deputy Chief Justice, Justices, I, together with my learned friends, Ms. Pillay, SC, Mr. Badlander, and Ms. Muvangwa, appear for the United Democratic Movement, the applicant in this matter.
Thank you, Mr. Mbofu.
May it please the court, I appear together with my learned colleague Tsetlo for the first respondent, the Speaker of the National Assembly.
Thank you, Mr. Moerane.
Chief Justice, Justices, I, together with Mr. Sikakani and Ms. Sello, appear for the second respondent.
Thank you, Mr. Semenya.
Chief Justice, Ms. Hobden and I appear for the fifth respondent, the Economic Freedom Fighters.
Thank you, Mr. Nkaitobi.
Chief Justice, other justices of the Constitutional Court, I, together with Ms. Paraffin-Jones, appear for the sixth respondent, that's the Inkatha Freedom Party.
Thank you, Mr. Gatz.
Chief Justice, other justices, I appear. My name is Lizelle Adams, and I appear on behalf of the eighth respondent.
Thank you, Ms. Adams.
Chief Justice and members of the court, I appear for the first amicus curiae, the Council for the Advancement of the South African Constitution, with my learned friends Ms. Adhikari and Mr. Mbikiwa.
Thank you, Mr. Badlander.
Chief Justice, other members of the court, I appear together with my junior, Mr. Bishop, for the second amicus curiae, the Unemployed People's Movement.
Thank you, Ms. Bawa.
May it please the court, I appear together with my learned friends, Ms. Talk and Ms. Ntloko, for the third amicus, the Institute for Security Studies.
Thank you, Mr. Maneche.
May it please the court, together with my learned friend Mr. Musandiwa and Ms. Finn, I appear for the fourth amicus, the Shosholoza Progressive Party.
Thank you too, Mr. Unterhalter. Mr. Mpofu.
As the court pleases.
Just for the record, all the parties wish not to be interrupted for 10 minutes and the amicus for 5 minutes.
We're indebted to the court, Chief Justice.
Thank you.
Chief Justice, this is a very important matter for our democracy. It's an important matter for all our citizens who are represented by members of parliament, whether those citizens are members of political parties, whether they voted or did not vote, whether they are even not of voting age. But thankfully, important as it is, this is a matter in which the issues are narrow and crisp, in my respectful submission. The only question which arises, and I was using this example when I was talking to the members of my team, to say, let's look at this as a multiple choice examination question. And the question then, bearing in mind that this is a matter that implicates the interpretation of primarily section 102.2 of the Constitution, as well as, to some extent, section 104, or rather Rule 104 of the Rules of the National Assembly. The multiple choice question, I pose it as follows. In respect of the secret ballot as a method of voting, the meaning of the expression, a vote, just those 5 letters, a vote, in section 102, is that a secret ballot is impliedly A, required, B, permitted, or C, prohibited. That is all that this matter is about. The parties will be seeking to various extents to convince you that the answer is A or it's B, as the applicants will do, or that it is C, as the respondents will do. The stances of the parties in general is that 5 of the parties say it is A or B. In other words, it is either required or permitted. 2 of the amici, Shosholoza and ISS, say that it is B, but they are neutral as to whether it is also A. And 1, the UPM, says it is B, but not A. In other words, it's permitted, but it's not required. And of course, the respondents will seek to convince the court that it is excluded, prohibited, outlawed, whatever other synonym one can find. Now, the only problem we have is that it is not very clear, and I'm saying this with an eye to inviting my learned colleagues for the respondents. The ambit and scope of the defense or opposition is very difficult to work out. We tried to do an exercise on our side to work out who is opposing what. And it was quite a difficult exercise indeed. For example, the president says that he only opposes prayers 3 and 4. But at certain parts of the affidavit and the heads, and in fact, at the end of the affidavit, it is said that the whole application should be dismissed. Similarly, the speaker says that she has no problem with the secret ballot. And her only trouble is that she thinks that she does not have a discretion to order one. And so presumably once that problem is resolved, there would be no problem. But again, at various parts of the pleadings or the heads, it's widened to the extent that she says the entire application should be dismissed. And yet, there is a press statement which is in the papers that she issued and went so far as to say she doesn't know where this notion comes from that she's opposing this application, because she just wants clarity on this and the other. And I'll make a reference to that at a later stage. But be that as it may, we work on the basis that the matter is opposed in different parts by somebody in the respondent camp. What is very clear is that both respondents raise what I call the preliminary matters, which is exclusive jurisdiction or direct access. Or I forgot to mention, Chief Justice and Justices, that the issue of agency is no longer going to be raised. I have cleared that with my learned colleague, Mr. Semenya. So the preliminary issues would be jurisdiction and direct access. When it comes to remedy, it would seem, and of course our learned colleagues will enlighten us when they get their opportunity, it would seem that the president's position is that it would be inappropriate for him to enter the terrain of the speaker, and therefore he does not express himself on the question of substitution or the review application. But when it comes to remedy, both parties raise the related question of separation of powers. That's the best we could do to work out who is opposing what, which relief. are going to go mainly on what we call the primary argument, which is that the secret ballot is required or mandatory or compulsory, and we'll be using those synonyms interchangeably. And only in the alternative are we going to talk about whether it is permitted or allowed or discretionary or optional and so on. Now, in doing so, one of the approaches we're going to take is firstly to demonstrate that it cannot conceivably be prohibited. In other words, the only obstacle that the respondents can bring for our case to succeed would be to demonstrate that it is prohibited, and we will show that that is out of the question. Then the only question should be whether is it required or is it permitted. There will be an overlap in my argument, Chief Justice and Justices. When I deal with what I call the primary relief, I will concentrate on Section 102 itself, the interpretation, the preferred interpretation of Section 102 to support that argument. But those arguments will be of equal applicability to the alternative. So I will not repeat them when I deal with the alternative. And what I will then do, with the leave of the court, is when I do the alternative submission, then the main thrust will be the interpretation of Rule 104, bearing in mind that the constitutional submissions will be subsumed therein. But while I still have uninterrupted time, I want to say this. Contrary to all the commentators out there about what this matter is about, this matter is only about one thing and one thing only: the interpretation, what interpretation is to be given to the legal instruments in question. In other words, the Section 102 and the rule. And that is the most mundane and boring and everyday function of the court. When the parties have a dispute, whether it's about a section, whether it's about a contract, whether it's about property, that dispute gets brought to a court, because that is the only place where such a dispute can be finally resolved. And so I'm making this point for this reason. This case is not about the separation of powers, nor is it about the so-called encroachment of the court into anything, nor is it about the court likely to introduce anything. If our interpretation of Section 102 is correct, then that interpretation was always like that since 1996, when the Constitution came into being. Nobody's introducing. The court will simply be interpreting what is. And if we succeed on the basis that the secret ballot is required, compulsory, mandatory, and so on, then with the greatest respect, the issue of separation of powers does not come into it whatsoever. Because there the court will simply be saying, yes, Section 102 should be interpreted to say that it is compulsory. End of the story. If it is compulsory, then it's compulsory tomorrow, next week, next year, in 20 years' time, and so on. And that's the end of it. Only if the court, on the other hand, finds in our favor in respect of the second leg, in other words, that it is discretionary. And even then, when it comes to the question of remedy and the question of substitution in particular, clearly then issues of separation of power powers become relevant in that narrow sense, because by definition, substitution means basically making the decision, for the court making the decision.
The 10 minutes is up.
Oh, well, Chief Justice, if you can permit me then to make the final point, which is this, that we will, in a nutshell, we will also ask for a special order against the President to pay costs personally and from his own pocket. And that I will address later. But in a nutshell, it is the complaint we raise is that the President was cited as a President of the country, and the ANC was cited as a party. The ANC chose not to get involved in this matter. But the President, using the state attorney or taxpayers' money, has sought to make submissions on behalf of the ANC, which is his private life or interest, so to speak. But we'll deal with that later. But finally, by way of introduction, I want to deal with what I'll call the atmospheric issues.
Are you still pleading for protection there, or may we?
Half a minute.
You see, I offered you people 15 minutes. You said 10 minutes is enough.
Half a minute, Chief Justice. And it is simply to say this. If the Speaker is to be believed that she has no problem with the secret ballot for a minute, and that she seeks, and one has sympathy with that argument, because insofar as she says, look, there's a Kawama judgment, and maybe I think I'm constrained by it, rightly or wrongly, then one can understand that. She needs clarification. If that is so, then really what do we have here? We have the following situation. The only person in this country who is opposing the application that the motion of no confidence in the President of the country should be conducted by secret ballot is the President of the country. I will say something more about that later.
Mr. Mbofo, I'm sorry. Shouldn't you start with what you described as preliminary issues? Why should we entertain this matter? What is the basis for us to hear it?
Yes. Thank you, Justice Chapter. We should. Well, the main thrust of these preliminary issues is the question of exclusive jurisdiction. Our submission is simply this. The entire source of I'm going to say that there are what I call sub-obligations and powers and so on, but the source of all this is the obligation on Parliament to hold the executive accountable. That obligation is by definition exclusive to Parliament, to state the obvious. But to travel from that obligation to the obligations that are pleaded here, we then say the following. In the discharge of that obligation, broadly speaking, in fact, let me put it like this. That obligation starts the minute that members of Parliament are sworn in. That obligation arises until the next election. And in the continuum of that obligation is the question of the motion of no confidence. It can manifest itself in various other ways, which I don't need to go into now. And the motion of no confidence itself is if you like, with respect, can be viewed as an obligation, except that it's now almost an obligation on the president. The section says, to paraphrase, if a motion is passed, the president must resign. It could also have been worded the other way. The president must resign when a motion is passed. So it's an obligation on his part to do something.
Mr. Mpofu, I'm sorry, and it may well be that my brother still wants to put further questions to you. Just locate the obligation for us. In the clearest of terms, what is the obligation that rests on Parliament on which reliance is placed for this application? Just locate it for us.
Well, that obligation is to vote in a motion of no confidence. In other words, once a motion of no confidence has been placed, there are three obligations that arise. One is on the Speaker to schedule such a motion, and then the obligation on the members, Parliament, broadly speaking, the National Assembly, let's put it that way, to vote. And also an obligation on the National Assembly to debate the motion. Those are the threefold obligations. But narrowly...
No, you were going there. I just wanted a section and a subsection so that we know whatever argument flows from here hinges on this section of the Constitution.
Those obligations, Chief Justice, correct, arise from 102.2 itself, and also the ancillary obligations on the Speaker, which is really why we're here, arise also from the rules. So in other words, the Speaker has a duty, at the very least, to schedule, to allow for the debate or arrange for the debate, and also to arrange for the vote. And we locate the obligation here that in her obligation to arrange for the vote, she has also an obligation to, when asked, as she is asked now, to choose the method of voting, to do so. She has abdicated, to put it bluntly, that the discharge of that obligation, and that is why we're here.
But the Speaker is not Parliament, is she?
Well, she is and she isn't. She as she has accepted that she has been cited as the representative of Parliament. So she's the embodiment of Parliament. When somebody is litigating against Parliament, we cite the Speaker in that fashion.
Doesn't the Constitution define what Parliament is, Mr. Mpofu?
Yeah, no, of course, the Constitution does, but what I'm saying, Justice Chapter, is that the Speaker must be seen in her multiple roles. She says herself in her answering affidavit, I'm cited here as the Speaker, I'm also cited as a representative of the National Assembly per se.
But should we go by that? Shouldn't we go by what the Constitution says, tells us what Parliament is, when we are searching for determining whether Parliament has failed to fulfill one of its obligations?
Yes, of course, it is like that, Justice Shafter, but just as when we say the Department of Home Affairs has failed to do something, that Department of Home Affairs is just an inanimate thing. The person who has really failed is either the DG or the minister, depending on the matter. But you can't say the Department of Home Affairs. There's no such thing as the Department of Home Affairs. It's just a fiction. So the real department is represented by an official who is designated constitutionally to represent that institution. And that's all we're saying. We're saying the Speaker then comes in two guises, as the Speaker, but also as the representative, the constitutional representative of Parliament.
But section 167, which carves out the exclusive jurisdiction of this court, make reference to Parliament.
Yeah.
And the Constitution tells us what Parliament is. Why should we include the Speaker in the description of Parliament?
Yes. Well, Justice Chapter, I can't take it further than to say, yes, the Constitution says Parliament, but Parliament is not a person. That section 167 also says the President. There it's easy. We know the President is a person. But when that same section, 167(4)(e), says Parliament, it obviously is not referring to a human being. It's referring to an institution. And that institution, constitutionally speaking, is embodied, represented by the Speaker. So otherwise, Parliament could never do anything. If you are never going to be able to pinpoint that it was either the Secretary of Parliament or this one or that one who did whatever they had to do, then you will never be able to come to this court on the basis that Parliament has done anything, because Parliament is just a fiction of law. So
let me just make sure I understand you.
Yeah.
And let me know if what I put to you is not what you're saying. Am I to understand you to be saying that the point that demonstrates the obligation that, according to you, rests on the Speaker and by extension Parliament, that has not been, that she has failed to fulfill is the following. Section 167(4)(e) reads, only the Constitutional Court may decide that Parliament or the President has failed to fulfill a constitutional obligation. And as I understand you, and that's why I want help from you,
yes,
you seem to be saying the obligation that rests on the Speaker is to ensure, as identified by the National Assembly, to ensure that when a request for a motion of no confidence is asked for, that happens the way it is required by the Constitution to happen.
Yeah.
And according to your submission, the way the Constitution requires that a motion of no confidence in the President be handled is by secret ballot.
That's correct.
So if the Speaker is asked to have a motion of no confidence scheduled in a way that will allow members of the National Assembly to vote by secret ballot, if she does not do that, according to your submission, she has failed to fulfill the obligation to have the motion of no confidence
that's
conducted. Is that what you are saying?
That is my submission, Chief Justice. And that submission rests solely on the fact that Section 102 says the National Assembly must do these things, must vote, must do this, but the rules are very clear who should organize, so to speak, all that. And our case is very simple, that the Speaker, on the primary relief, the Speaker has an obligation to arrange for a secret ballot. That's our primary relief. Whether we're right or wrong, for the purposes of jurisdiction is another matter. For the purposes of jurisdiction, it is about what are we pleading. We are pleading that the Speaker has such an obligation to arrange the secret ballot. And she has failed to discharge it. That is all. We might be found when we get to the merits to be wrong on that, but for the purposes of jurisdiction, we must be judged by what it is that we've brought to this court. which is simply that she has failed to discharge that obligation. That obligation arises, yes, it is ancillary, that I concede, but it arises from the obligations that spring out of Section 102.
I'm sorry, Mr. Mpofu.
Sorry.
Just for clarification, going back to the question that was asked by my brother, Justice Jafta, just now,
Yeah.
with regard to Parliament. Now, as I understand the Constitution, Parliament consists of the National Assembly and the National Council of Provinces. Now, does the Constitution or the law permit the Speaker of the National Assembly alone to represent the entire Parliament, or you would have had to cite the chairperson of the National Council of Provinces as well?
Well, two answers, Justice Sondo. One is that, once again, if the business about which we are here, let's say Parliament had 3 or 4 chambers, but if the business about which we are concerns one of the chambers, which is represented constitutionally, as I've explained, by a specific person, then that person, with respect, would be sufficient to cite to represent the institution, number one. Number two, that point, well, is not a point that has been raised, and for good reason. Because in all these litigation, whether it's Tlawama and all the other cases that have come before this court, the person who gets traditionally cited is the Speaker, on the understanding that I've just articulated. Whether it was the EFF Nkandla case, whether it is this one, and all the cases where Parliament is implicated. And the reason for that is also to be found in Section 23(2)A of the Powers and Privileges Act, which simply says, 23(2)A, for the purposes of subsection 1, where appropriate, that's a reference to the State Liability Act and so on, of a minister, department must, where the proceedings are against where the proceedings are against Parliament or a House, coming to what you raised, Justice Jafta, be construed as a reference to the Speaker or the chairperson, or both the Speaker and the chairperson, as the case may be. In other words, a litigant, there would have been nothing wrong if we had followed the route that Justice Zondo suggests. We could have cited both, could have cited the one, or we could have cited the other. And we have cited the other.
Well, I'm sorry, you might have to repeat the provision you have just read.
Yes, it's section 23(2)A.
Okay, I got the impression from what you read that what is meant is that if you seek to cite somebody in respect of the National Assembly, then you would cite the Speaker.
Correct.
If you seek to cite somebody in respect of the National Council of Provinces, then you would cite the chairperson of the National Council of Provinces. If you seek to cite somebody for Parliament, I don't know if it goes that far, I'm just thinking now, maybe you might need to cite both. Maybe you might just read it again.
Yes, no, with respect, it says Parliament or a House shall be construed as a reference to the Speaker or the chairperson, or to both the Speaker and the chairperson, as the case may be. But in any case, Section 42.3, when I started, I said all these obligations can be traced back to Section 42, or rather to the 42.3, yes. 42.3 that we're about here says the following. The National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the president and so on and so on. So the obligations that we're about here today lie on the National Assembly. Hence, if you read that section of the Constitution together with 23(2)(a), then the person to be cited would clearly be the Speaker.
I'm not too sure I understand your answer, Mr. Mpofu. I thought your, at least in my own mind and clarified, it seems to be different from your own understanding. I thought, to the extent that Section 167(4)(e) refers to Parliament, and Section 102 refers to the National Assembly, and the National Assembly is not Parliament, it's a segment of Parliament, one of the two houses of Parliament. Your reliance on the Speaker would stem from the same basis as in the EFF case that we decided, namely, requiring of the National Assembly to hold the President accountable in terms of Section 55 of the Constitution. Let me put it differently, I'm sorry. 167(4)(e) refers to Parliament, but 55 refers to the National Assembly. And yet, for the purpose of determining whether this court had an exclusive jurisdiction, knowing that Section 167(4)(e) refers to Parliament and not the National Assembly, whereas 55 confines itself to the National Assembly, we were still able to decide that a reference to Parliament in 167(4)(e) should be understood to permit of a situation where the National Assembly is singled out to do something, as in Section 55 of the Constitution. I don't know if I'm making sense to you. So a reference in 102 to the National Assembly is the same as a reference to the National Assembly in 55.
That is correct.
You can't use, is it State Liability Act? You can't use that to interpret the Constitution. You've got to use the Constitution and existing jurisprudence to interpret the Constitution.
Of course, Chief Justice, that is not what I was doing. What I was saying is, let's say, for example, there was a rule of court that says you will only cite the Speaker. I would cite that rule, but I wouldn't be using that rule to interpret the Constitution. And what the Chief Justice has articulated is exactly what I'm saying. The 102 is our starting point, and the obligation, power, whatever you call it in 102, is on the National Assembly per se. And everything else then flows from that. Section 55, as the CJ correctly points out, and also Section 42, which I've just read out, all refer to the obligations of the National Assembly. And on the same basis in the EFF case and in all the other cases. So
I was only saying there is a case that says, effectively, in circumstances where the National Assembly is said to have failed to fulfill its constitutional obligations, we already have authority that says, if you want to check whether Section 165(4)(e) kicks in, and it's only the National Assembly that is referred to in that section, then there is authority.
That's correct.
Yes.
Mr. Mpofu, I'm sorry. I think my inquiry was a different one. I started by bringing your attention to the provision of the Constitution that defines Parliament. And that provision is actually Section 42. And it tells us that Parliament consists of the National Assembly and the House of National Provinces. Now, the issue is whether, in the context of Section 167, for purposes of exclusive jurisdiction of this court, whether we should read National Assembly as meaning the Speaker. I thought the Speaker is one of the members of the National Assembly. So if we can read National Assembly to mean the Speaker, if at some point she takes a decision, that decision should be attributed to the whole National Assembly, then I would understand the argument.
Yes, well, it is the argument, Justice Chapter. When Mr. Ngamayom Zinkwankwa wrote on behalf of the UDM to the Speaker asking for a motion of no confidence, he was not writing to Ms. Balekambete. He was writing to the National Assembly, which is tasked in terms of Section 102 to do something. But he couldn't just write a letter and address it to the National Assembly. He had to address that letter to the person who, in terms of the section, the State Liability Act, the Powers and Privileges Act, is by law the embodiment of that institution and is the person to be cited when that institution is being taken to task. We are saying, I agree exactly with that formulation. So it's the Speaker, both in the failure to carry out the obligation and in her being cited here, is the embodiment of the National Assembly. As court pleases.
Mr. Mpofu, as you know, it's either exclusive jurisdiction or direct access. If you could also address us on that point.
Yes.
And in particular, the allegation that the applicant should have exhausted internal remedies and how you say, I can't pronounce it, Tlowama is distinguishable, because there's also the allegation that applicant should have appealed the judgment, yes, and he did not do so.
Well, very briefly, Justice Mhlanhla, what we're saying there is that, and again, I won't repeat the test, in the broad context of the interest of justice, we are saying, and given the fact that this is a matter that is inherently urgent, we're saying, assuming then that we had taken the matter against the Speaker, then we would have had to go to the Western Cape High Court. And one of the issues that relate to Tlowama, which we would like the court to consider in the broad consideration of the interest of justice, is this. Putting aside the fact that we are saying Tlowama is distinguishable, because remember, we're saying Tlowama is distinguishable, but we're also saying it was wrongly decided. So we're saying two things about Tlowama. But if we had gone on an urgent basis to the Western Cape High Court, bearing in mind that Tlowama was a full bench decision, then that court would have been bound by Tlowama. So that's the one thing we say about Tlowama to be considered. And therefore, it might have been a futile exercise to do that. But secondly, what we say is that Tlowama also, maybe fortuitously, resolves another impediment which is always on the way towards direct access, namely that this court is reluctant to be the court of first instance on an issue. Tlowama, therefore, then provides a situation where the question was decided wrongly, in brackets, but nevertheless was considered and decided in a lower court. So Tlowama serves those two purposes. One, the futility approach that I've spoken about, and secondly, it fortuitously takes away the impediment of this court in reality being the court of first instance.
Please go back to my sister's question in case you haven't completed your answer. But could the Speaker do anything when Tlowama is there?
Well,
without disregarding a court decision?
Yes, she could. That is why in my 10 minutes, I specifically said, we have great sympathy with the position of the Speaker. Because the Speaker is not a lawyer. She's not going to pick up the judgment and say it's distinguishable and all those things that we say as lawyers. So we understand. But remember, for example, when we deal with the rationality of her decision, the test is objective. So it doesn't matter if subjectively she thought Tlowama binds her. It doesn't matter. If Tlowama, in actual fact, is wrongly decided or distinguishable, as we say, particularly if it's distinguishable, the IFP, I'm sure, will raise that point. The IFP raises the point that Tlowama actually is distinguishable on the grounds that it was a case decided on another set of rules, not these rules. That is a criticism that we have. But we say, assume that was not there, it is also wrongly decided. So whether it is because...
I'm sorry to interrupt. You know we interrupt, Mr. Mbofu.
No, of course.
No, I'm not even there. I'm saying, here is the Speaker told that, this section 102, subsection 2, demands of you, requires of you, to arrange that voting on a motion of no confidence against the President be by secret ballot. And she's confronted by Tlowama judgment, which says, but there is no way in which this motion can be conducted by a secret ballot. How does she disregard a court judgment like that? Even if she thought it was wrong, it's there.
Well, Chief Justice, with the greatest respect, then we must go back to where this matter comes from. This matter comes from the letter of demand that was written on behalf of the UDM.
Mr. Mbofu. Sorry, Mr. Mbofu. Mr. Mbofu.
Yeah, I'm listening. Yes,
yes.
Just.
The question by the Chief Justice assists you. Mr. Mbofu, I'm trying to point out that what the Chief Justice is pointing out is that the Speaker could not have taken any other decision in view of Tlowama.
Yeah.
And therefore, it supports your submission that you are entitled to come here and ask for direct access.
Absolutely.
Thank you.
No, but that's a... But why else am I saying this? The only reason I'm saying this, Justice Chapter, is exactly to agree with the Chief Justice. I am saying this is why I said it in my introduction. We have sympathy with the Speaker, but that sympathy ends at the point at which she was bound in her mind by Tlowama. The only other place we could go to is here. That's all I'm saying. Yeah, probably. Yeah. Well, thank you. So that's the end of the preliminary issues. Now, oh yes.
You are left with 15 minutes.
Thank you, Chief Justice. Yeah.
Mr. Mbofu,
yes,
perhaps you should just go straight and tell us why you say the vote is required or permitted to be by secret ballot.
Thank you. Well, we say this based. Firstly, we say that the vote is prescribed to be by secret ballot because it is common cause that a secret ballot is what we call a constitutionally permissible method of voting. And I'm saying that as a precursor to something else. Why do we say it's constitutionally permissible? When we invoke Section 86 and the procedure in Schedule 3, we invoke it for two reasons. The first reason is to make this point that this is a constitutionally permissible method. And it immediately does away with one of the defenses that are raised, namely that we want to introduce some secret society, or that the values of openness and transparency and so on will be undermined. We say that that cannot be so. If that was so, if a secret ballot was such an animal, then the Constitution would not prescribe it under any circumstances. In other words, the value judgment, the hierarchy of values, so to speak, if you take it to Section 1D, which talks about all these things. It talks about accountability, it talks about democracy, it talks about transparency, it talks about openness. We say in this context, the hierarchy of those values is already determined by the Constitution. Because the Constitution has said, yes, there will be so-called encroachment into openness. But because of the bigger values of protecting the voter, then we will allow a secret ballot. It's the same in Section 19. Section 19, of course, it would be nice if all the citizens would vote in the open and raise their hands. That would be great for openness. But the Constitution, the drafters of the Constitution in their wisdom have made the choice of values to say, no, we know that would be great for openness, but we're going to prescribe that the vote must come by way of a secret ballot. And that argument, it goes right to the international stage. The United Nations Declaration for Human Rights, no less, knowing all the importance of openness, says that the vote internationally must be secured by way of secret ballot. So it is that submission. But the second reason why we invoke Section 86.3, Section 86 together read with Part A, is what we call what I call the Masetla congruence. In other words, we're saying, we use a rhetorical question, maybe is the best way to approach it. Why is it that the Constitution prescribes a secret ballot in Section 86? The answer must be simple. It is to protect the voter. Against what? Against possible intimidation, not necessarily all intimidation, but the risk of intimidation, the risk of any threats, the risk of any adverse consequences. When we say the citizens must vote by secret, we're not saying that in every voting station in this country there's somebody standing there to intimidate somebody. That would be ridiculous. What we're saying is the mere risk or potential or likelihood of such a thing happening constitutionally compels us to prescribe the secret ballot.
Mr. Mpofu, isn't there another reason why the Constitution mandates a secret ballot when more than one nominee is nominated for the office of President? Isn't it because the execution of the office of President is deeply connected to the personal attributes of the person who's up for election? And that therefore at that level it's not simply a nominee from a party, and that MPs are required to vote for the person of that individual who will become president in their individual capacities.
Yes, no, that is definitely so, Justice Cameron. But our short answer to that is that just as those considerations are important when we choose the president, The same considerations must be important when we unchoose the president. In other words,
I'm glad you're better able to discern the questions that are designed to assist you, Mr. Mpofu.
yes, thank you. That's good. And welcome them with both hands, as God pleases. So that then is the ground for 86.3. Or for invoking 86. But there's a more maybe dramatic reason. And it is this. The Speaker, I call it the crime prevention rationale. In its wisdom, the Parliament has declared intimidation of members of Parliament a crime. That is Section 7 and 8 read with Section 27 of the Powers and Privileges Act. So then surely that must put an obligation on the Speaker simply to do what she can do to prevent that crime from being committed. And that cuts both for the primary and the secondary relief. Because in this particular case, it so happens that the crime, quote unquote, has been reported in the letter of demand. But in the notional situation, the crime is a potential that is always with us. Just as fraud, bribery, corruption of voters, and so on. Those ever-present risks must be ameliorated. And the shortcut answer is that of the available methods, the only method that can prevent that crime from either being committed in real life, in this particular case, or as a risk that is always there, is the secret ballot.
Which crime has been reported?
The intimidation.
Which one?
Section...
No. I know the section. I thought you said a crime has already been reported.
Yes.
So I was wondering which crime has been reported.
Yes.
Now.
I will assist you, Chief Justice. The letter of demand says, I'll paraphrase. Letter of demand says, Dear Speaker, there's a motion of no confidence. It has come to our attention that there is intimidation that is taking place. In any event, and then it quotes the sections that we have already dealt with, therefore, please arrange for a secret ballot. So that is bringing to the attention of the Speaker in this balance, the crime specifically. But what I'm saying, Chief Justice, is that even if that was not the case, the ever-present danger of intimidation is what propels Section 19.3 to make all of us to vote by secret ballot.
Shouldn't we go there? Because it toxifies the engagement. If we're going to have to, as a court, take into account that some crime has been reported, it raises all sorts of, by who? Is it a crime? Also, shouldn't we just look at the law and interpret it?
Yeah, but
crime or no crime, suspected or real, just look at the law and say, what is the meaning of Section 102.2? Why is Section 86 couched in this manner, read with the schedule? What undergirds the approach in Schedule 3, Part A, Item 6A? Why do we have it like that? Yeah. Why is it necessary when the president is elected to do it by secret ballot?
Yes.
What are the concerns there? Do they or do they not extend to the removal? Which one is potentially more perilous than the other, if there is any peril?
Yes.
Is it when you entertain the hope to be elected, or when you face the risk of being denied of what you already enjoy? Shouldn't we be engaging at that level? Because now if you're going to say, yes, there's an offense, there's some criminal activity, it just makes it all the more difficult for the
Chief
judges to do justice to the issues.
I think there's a misunderstanding.
Yes.
I was doing exactly what the Chief Justice is saying. It's called the mischief approach. I am saying, why? That's why I said I'm asking the rhetorical question, which is exactly what the Chief Justice, with respect, is saying. What was the mischief that propelled Parliament to, or the Constitution rather, to prescribe in Section 86 the secret ballot? That's exactly what I'm saying. And I'm saying that mischief includes actual or perceived or potential risk of intimidation or fraud. That is all. And that potential, with the greatest respect, I agree with the Chief Justice, that potential risk, whether it happens to be actual or not in this case, I agree it should be put aside. But that ever-present potential, in my respectful submission, is present, is more present now. Or let me put it in a different way. Its realization, or even its mere presence, is a threat to the effectiveness of the Section 102, the operation of Section 102. And many adjectives have been used here to say that it would then be illusory, nugatory, warped, is the expression that Justice Madlanga used in the DA case, meaningless, blunt, all sorts of stuff. But that's the essence. The essence is that that right would be denuded of its essence, of its purpose, coming to the question of purposive interpretation, and might as well not happen. In fact, we might as well not have the Section 102 if it can be so denuded of its character and impact and teeth. Toothless was the other adjective that was used. So it would be rendered all those things. And surely then, if we have all those ailments, and we are saying, here is the antidote. To all those ailments, there is only one antidote. That antidote is the secret ballot. Immediately, the teeth are back, all the strength is back, the Section 102 is given its power back. Yeah. That is the crux of the. Yeah.
If I may, just for the benefit of other counsel that will debate, that will make submissions later. Here are my concerns, and I would be helped speaking for myself if this were to be addressed. One, why does Section 19(2) of the Constitution require a vote by secret ballot? Why does Section 86, read with Schedule 3, Part A, Item 6A, require a secret ballot in relation to the President? What is the logicality of discounting a secret ballot when it comes to a motion of no confidence? And I confine it to a motion of no confidence because that's where we are. Why do we believe that considerations that explain the need for a secret ballot in relation to Section 19(2) and the schedule do not extend to a motion of no confidence? Is it because it's not written? What are we to make of the Botswana judgment that you refer to? What are we to make of the Zimbabwe Supreme Court judgment that you referred to and other of your colleagues also referred to in their heads of argument? Just a simple explanation that everybody can relate to. I think we'll contaminate, for want of a better expression, and I say it with all the respect, nobody should feel offended. We stand the risk of being diverted, our attention being diverted elsewhere. If we bring in, yes, so on whom was an assassination attempt, for what reason, and so says so was intimidated. I'm not too sure we should even reflect on those things, because the law is there.
Yes.
Regardless of what is said to have happened. How is this law properly interpreted, or this constitutional provision properly interpreted to be applied in a situation like this, regardless of who is the incumbent and whether we like or hate the person? That's irrelevant.
Completely.
So I think, speaking for myself, if I were to be addressed on those issues, I would find a lot of help.
Yes. Chief Justice, that is the point. If I didn't make the point in my 10 minutes, well, I'm making it now. The issues of intimidation, this one phoned, this one, do not enter into our primary...
SMS and all those things.
It doesn't enter into the primary obligation at all. Just as I said, all these other issues about separation of powers and so on, the question is very simple. If we apply a constitutional interpretation of Section 102, a holistic, schematic, systematic interpretation as we are prescribed to do, and this is a challenge I'm putting to my learned colleagues, they must then tell us in that context, what is wrong with the secret ballot? Why must it be excluded? Because their case can only be that it is excluded. Why would it be excluded? We're busy giving you reasons, and many parties will, as to why it must be there. But nobody has told us what is wrong with it. And all the things that have been put up, party discipline and so on, do not answer the question, which is that a method that is constitutionally permissible for all the reasons, whether in Section 19 and all the other sections, Section 111 and so on, is now said to be, because of the vitality and all the things we know from Mazibuko of this particular, and the risk, and I put it no higher than that, the risk of the outcome being contaminated, whether that risk is going to materialize in this or the next or in 100 years' time, it doesn't matter. But the mere risk of the outcome not reflecting the real thing that all the South Africans want to know, Chief Justice, with respect, is very simple. Does the President continue to enjoy the confidence of the majority of the members of Parliament? That's all. Now, if he does, well, then he does. But to answer that question, just as we do in the elections, the question is simple. Which political party enjoys the majority support of South Africans? And we bring the secret ballot to make sure that the answer that we get must have integrity. It must be the real answer. It must be untainted by any extraneous factor, whether that factor is fraud or fear or whatever. And that is all. It's a very simple antidote, as I call it, that we are waving respectfully to this court to say, here is the antidote for all these ills, real, potential, whether they've happened or are still going to happen, or whether they're not going to happen right now in this particular... and therefore, that brings
Mr. Mpofu,
Justice Matlanga.
It's quite plain from sections 19 and 102 read with the relevant schedule that the framers of the Constitution were quite alive to the need for a secret ballot. Can't an argument be made then that they must have consciously decided not to prescribe it when it came to a vote of no confidence?
Yes.
Can't it be said that, well aware of the need for it in the instances where it has been specified, that perhaps they chose openness, transparency, and so on, which in your submissions you did say is also a relevant or may well be a relevant consideration. Can they be said to have made a conscious choice and said, when it comes to a vote of no confidence, we are opting that there be no secret ballot?
Mr. Bofo, before you respond, may I latch on what my brother has just stated? My own concern is what should we make of the fact that the Constitution in some places expressly requires a vote by secret ballot, as in Section 19 and Section 86, but does not do so in Section 102, subsection 2. It's just to latch on what Justice Madlanga has just put to you.
And please, I'm aware of the authorities that criticize the use of the expressio unius exclusio alterius principle. So I'm not there at all. I'm at an interpretative level.
Yes. Well, unfortunately, Justice Madlanga, it's just the Latin. It's just the Latin. But the sentiment that both Justice Madlanga and Justice Khambembe are expressing is embodied in that maxim, quote unquote. And it makes sense that if in a statute the law says this and this will happen and then doesn't say it in another section, then the presumption would be that it was meant to exclude it. But it has been authoritatively said that that type of reasoning is not appropriate with respect to what the Canadian case called charter interpretation.
May I interrupt you, Mr. Mbofo? What my sister and my brother are saying is this. Could it be that the drafters of the Constitution, mindful of the principle of separation of powers, wanted this arm of the state to bear the responsibility to decide how they would want a motion of no confidence to be conducted?
Yes.
Because they knew they are the ones who included secret ballot elsewhere. Could it be that they left it to the National Assembly? Whenever you people think that it must be by secret ballot, it's up to you. Whenever you think that it should be by open ballot, it's all up to you.
The first answer is it could. I'm going to show why it isn't so. It could. And if it could, if even that formulation, Chief Justice, would be sufficient for us to succeed on the alternative ground. In other words, as the Chief Justice says, the law would then be saying, we are neither prescribing nor prohibiting the secret ballot. But then what are we doing? Then what are we doing is what is in prayer 3.2. We are then saying, it's up to you. If and when you think it should be done, it will be done. But that is a far cry from what is being contended by the respondents, namely that it's excluded. But let me now address the second question, which is why it is not by the use of that, or rather why it is prescribed nevertheless. The reason, with the greatest respect, and that is debated in the Botswana case, in both the lower court and the higher court. The reason the expressio unius kind of reasoning is not prescribed or says ill-suited for constitutional interpretation is exactly because it is best suited for statutory interpretation. Whereas in constitutional interpretation, what we are compelled to do is to look at the scheme of the Constitution. Now, if you're going to look at the scheme of the Constitution, you will never get anywhere by saying, well, if in this particular provision it's not there, therefore it means it is excluded. Because as Mr. Halter will explain later, one has to look at the entire Constitution, including the Bill of Rights. One has to consider that, after all, these members of Parliament are also citizens of South Africa. They have the right, in terms of Section 15 of the Constitution, the right to freedom of conscience. They have the right, in terms of Section 16, to freedom of expression. If you want to go to the intimidation route, well, they have a right to life, they have a right to personal integrity, and so on and so on. So a schematic, you will never get anywhere by using the expressio logic in interpreting a constitutional provision, because by definition, it is unsuited for that. So we cannot say the drafters. In fact, constitutions, by definition, this thing called a constitution, whether it's a constitution of a country or of a football club, is a framework. It's a framework. It will never foresee all possible situations. Life gets breathed into it by situational happenings.
I'm sorry, Mr. For motion of no confidence is there.
Yes.
You know it is there. You're prescribing for how to vote a president into office, but you're not telling us how to vote him or her out of office, you see. I'm just making the statement in passing that one is not some development that might arise in the future. It stares you in the face as you craft the Constitution.
Yes, well, that is so, but so does it, all the Masetla logic, so to speak, is exactly based on that. Whenever the instrument being examined, such as was being examined in Masetla, is silent. That instrument was silent on how the DG of Intelligence should be fired. And that did not mean that the drafters of that act thought that he should never be fired. It was silent. And therefore, the court then says, okay, well, where does this power, what is the closest other power, the ancillary power? It is the power to hire. And the court then says, well, in that particular case, he who hires, fires. Now we're saying, as the court, please, in that case, it was a he. President Mbeki. Yeah.
Just on the point you are dealing with,
yes,
I have reservations whether you are correct to invoke the unius rule of presumption to deal with the question that has been raised, questions that have been raised by my colleagues, Justice Jafta and Justice Kampebe, because my understanding is that when one seeks to interpret a constitution, one of the things that you have got to bear in mind is that the drafters of the Constitution may have made certain choices, which, for example, the judiciary must respect. For good or bad reasons, to bring about a constitution, a complete constitution, there are certain issues that they had to deal with. And in regard to those issues, there may have been different views from different stakeholders, different political parties, and they make certain choices.
Yes.
And the judiciary should not, if possible, interfere with those choices. Now, as I understand the question that was put to you by my two colleagues, it is that when you look at the Constitution, you see that in certain sections and in respect of certain office bearers or functionaries, the Constitution is clear. It prescribes a secret ballot. It doesn't give a discretion. It prescribes a secret ballot. So that means, that seems to suggest that for those situations, the drafters did not want to leave it to somebody to decide whether this time it should be a secret ballot, this time it should not. And then they say, in a number of sections, then the Constitution doesn't prescribe a secret ballot.
Yes.
Are we therefore not dealing with a situation where where the secret ballot is not prescribed, that was not as a result of oversight. That was deliberate. For whatever reasons that we may or may not think about. Yes. And therefore that to a very large extent, we must try and give effect to those choices that have been made.
Yes, I understand the question, Justice Zondo. My answer is this. Firstly, as I said to the Chief Justice, even if that were so, that would not operate to exclude the secret ballot. So we would still have to succeed on the alternative. But let's put that aside. As far as the primary prayer is concerned, the answer is this. Yes, of course, Justice Zondo, it's possible. Anything is possible. But my job is to convince this court that that choice was not made, that that choice would be illogical in the totality of the circumstances, that that choice might even be oppressive, that that choice might take away the teeth from the intended effect of Section 102. And therefore, and even more, if that choice was going to be situational, and this time it's secret ballot, next time it's open ballot, tomorrow it's by standing up or sitting down, that would create chaos because, as pointed out by one of the amici, then it would mean that every time there's a motion of no confidence, we must come back here. Somebody this time will say, I'm applying that it must be open. In 2 years' time, I'm applying that it must be secret. So that could not have been the intention of the drafters of the Constitution. And that is what I have to do.
But Mr. Mpofu, am I right? Mr. Mpofu, I'm sorry. Am I right to think that in order to uphold your primary contention, this court would have to say there was no choice made, but it was oversight?
Yes, and it would also have to say the following, Justice Zondo. Again,
before you continue, I must just complete.
Yes.
If you say, this court would have to say, it's oversight, which you have said we would need to say, but you want to add. If you say this court would have to say it was oversight that in some cases they didn't say prescribed secret ballot, part of my difficulty would be, it seems to be quite a number of places. Could one really be able to say, in all these other cases, it was oversight?
No, absolutely not. One would not be able to say that. But one would be able to say it when the subject matter is so identical, congruent, a mirror image of those situations where it is prescribed, that it would be absurd to say that it is not.
Mr. Mpofu, may I interrupt your answer?
Yes.
Does it help us at all to go back to the death penalty debate? Because there it was an express, we don't have any suggestion from the parties that in the preparatory work, travaux préparatoire, there was any debate about this. There's a silence in the Constitutional Assembly history so far as we've been told by all the parties. But in the death penalty debate, there was a lot of debate, and the parties differed. And they agreed to leave it out of the Constitution, which doesn't mean that the Constitution doesn't have a meaning. So does it help us in any way to determine the meaning of 1022?
Yes, that is correct, Justice Cameron. In other words, really, my broad submission is this: an omission is not an exclusion. Simple. And the second stage to that is that, because that is the mistake that the respondents make, that an omission ipso facto is an exclusion.
I'm sorry to
But-
interrupt you.
Sorry.
If the omission is not necessarily an exclusion, and the choice is not clear from the wording of the Constitution, how do we then determine it? Is the real question then not to ask how best is the purpose of National Assembly oversight over the executive served by either a secret ballot or not?
Yes, absolutely, Justice Fromneman. The purposive approach helps us. But with respect, what I'm saying is that it would not also be true to say the choice is not clear, because the drafters of the Constitution, in what I would submit are almost identical situations where the dilemmas are the same, where the vexing questions are the same, the dangers are the same, and so on, has prescribed an antidote. All I'm here saying humbly is that that antidote, which is prescribed for those situations which are similar, identical, I don't know, on the continuum of the mirror image, that antidote must have been, that's my argument can only be, must have been contemplated. If it was not, then it was either an oversight or, as in the death penalty situation, it was a question deliberately left for this court to decide. Because Justice Cameron is right. Nobody in their right mind can think that it didn't occur to the drafters of the Constitution that there's something called the death sentence. But they crafted the Constitution in its totality in such a manner that it would be settled, this court would be settled with that question. And this court rose to the occasion and answered that question. I'm saying it is that species of an omission. It is not an omission which is ipso facto an exclusion, definitely. It may, as Justice Zondo says, be an oversight. But I go further to say it is of the genre that Justice Cameron is
I'm sorry, Mr. Mbofu. Yes. Isn't it that after the elections, Parliament sit? In the first sitting of Parliament, the President is elected.
Correct.
And that is why then, in the process of electing the President, the Constitution gives us the details as to how it should happen. But we know from Section 57 of the Constitution that Parliament is the master of its own procedures.
Correct.
So the drafters of the Constitution knew that after the first sitting, Parliament will adopt rules which would regulate its business. And in those rules, Parliament will deal with these issues. So it was left to Parliament to determine whether certain voting should be done by secret ballot or not. Isn't that the position, the structure of the Constitution?
No, it is not, Justice Chapter. Because if that was the case, then the section that deals with actually what's going to happen if the motion of no confidence carries. What will happen is that within the next month or so, the clock will be wound exactly back to June 2014. Even though Parliament has been there, it has done all its rules, but exactly the secret ballot vote that will happen for the replacement president is still going exactly. So that can never have been the motivation for the chapter 3, rather schedule 3.
Can I draw your attention to section 57?
57.
Let's look at section 57.
Yeah.
It says, the National Assembly may determine and control its internal arrangements, proceedings, and procedures, and make rules and orders concerning its business, with due regard to representative and participatory democracy, accountability, transparency, and public involvement. The rules and orders of the National Assembly must provide for, and it lists a number of issues.
Yeah.
What does that tell us? Doesn't that tell us that the Constitution has left it to Parliament to determine these issues? More so, if you go to Section 59, you'll see that Section 59 does something that is not ordinarily done. Rights may be limited. Rights in the Bill of Rights may be limited by rules of Parliament in Section 59, just to show that how important the drafters of the Constitution regarded rules of Parliament to be.
Yes.
Maybe before you answer, all the instances, all the countries you referred to, all the countries that Mr. Bartlander referred to, where voting was or is done by secret ballot, or courts spoke in support of voting by secret ballot. The rules of parliaments in all those jurisdictions make that provision. Just to support what, to add to what my brother has said. Yes. Parliament has itself, in all those instances, decided that this is how it's going to be done. And courts came in to interpret what Parliament, in the exercise of its constitutional power, had decided to do.
Chief Justice, I would differ slightly with that. In the case, for example, of Ghana, the Constitution prescribes a secret ballot. In the case of Korea,
the rules.
Well, Mr.
Same Botswana, Zimbabwe, Germany, all these other jurisdictions, the rules prescribe secret ballot, not the Constitution as such.
Well, in the case of Korea, not even the rules deal with the question. What happened in South Korea in 2016 is that, in actual fact, in the impeachment of the president there, a secret ballot was used.
But who decided?
Well,
was it the court or Parliament?
No, of course, it was not the court, but the rules, all I'm saying is that it's not as if the rules provided for that situation, which is exactly why it was challenged. That challenge failed.
Please allow me, Mr. Mpofu.
Sorry.
Who decided that it be done by secret ballot? Remember, we are dealing with my brother Jafta's question.
Yes.
It's like I'm a staff writer here.
Yes.
Who decided that it should be by secret ballot?
Well, the answer is, it could have been Parliament itself. It could have been the Speaker. We don't know.
No, please. I'm sorry. I'm sorry. The point I want to make is it is not the court that decided so.
No, of course.
It was an internal arrangement within Parliament itself. Is it not so?
Absolutely.
Now deal with my brother's question.
Yes.
With that understanding.
Yes. And by the way, before I deal with that question, that's exactly what the UDM was asking for. That's why we wrote a letter to the Speaker. It was not to say the court must decide. It was to say she must decide. And she failed to do so.
I'm sorry, Mr. Mpofu. It was, but is it for the Speaker to then decide under those circumstances, consistent with what I've drawn your attention to in relation to other jurisdictions? Is it not for the National Assembly?
Well, it is for the National Assembly, but the rules have delegated, for lack of a better word, that function to the Speaker. The rules say simply, at the direction of the Speaker, and I'm paraphrasing, at the direction of the Speaker, the procedure to be adopted will be imposed. So it's the same. The answer is the same. As court, please.
So your alternative argument is the one that you're relying on, rather than the oversight issue, because that is the argument that I didn't understand.
Yes.
I understand the alternative argument to say the rules of Parliament permit the Speaker to direct that voting shall be by secret ballot.
Yes.
And therefore the Speaker was wrong in thinking that she doesn't have the power.
Absolutely. That's the argument. And what we then say, assuming that, well, in the alternative argument, what we say, Justice Chapter, is that in any event, Rule 104, properly interpreted, cannot be read in any other way but to permit a secret ballot. When that rule says, ordinarily, and I'm paraphrasing again, ordinarily, when the so-called electronic voting is done, then at the end of the meeting, the names and votes will be reflected in the minute. Then we know, all of us, what we're talking about. We're talking about an open ballot. But when the same rules say, if the method that has now been chosen by the Speaker permits for the names and votes to be reflected in the minutes, then this and that will happen. Then obviously, what that same rule is saying is that if, on the other hand, the method chosen by the Speaker does not permit for the names and the votes to be tallied, they will not be reflected in the minute. What is that, in short? A secret ballot. It is nothing else. Once you have a situation where the votes and the names are incapable of being tallied, in other words, it's undetectable whether Mr. Mpofu voted this way or that way, and for that reason, the votes cannot be reflected in the minutes. That is nothing else but the secret ballot. Whether that secret ballot is going to be achieved by throwing stones or raising hands or putting X on a piece of paper is irrelevant.
Well, on a lighter note, Mr. Mpofu, I don't think if the National Assembly or the Rules Committee wanted to say secret ballot, they would have spoken in encrypted or coded terms. I think they would have been expressed, particularly in view of what the Constitution itself says. But that's on a lighter note.
No, I understand that, CJ. Unfortunately, even if it's on a lighter note, I'm going to address it. The issue there, Chief Justice, is that this is simply an exercise in interpretation. And all I'm saying about Rule 104 is that Rule 104, insofar as it contemplates anything that might, wherein the vote and the name might not be tallied, then that thing, in whatever form it comes, is a species of a secret ballot. Because a secret ballot is, yeah. I'm sorry, CJ, a secret ballot simply means we shall not be able to detect who voted what.
I've got a conceptual difficulty with the approach, but I think we have overburdened you. Yeah. I think the starting point should be, how do we interpret the message communicated by Section 1022 yes. In relation specifically to the method of voting? Yes. And then you can then move from there to the rules. But yes. for as long as it doesn't look like the National Assembly understands Section 1022 to be saying secret ballot or suggesting secret ballot, I am not too sure that the rules yes. themselves could go that far.
Fair enough.
But not for you not to answer the question, but I'm raising it for everybody else. Here is the question I want to raise. It relates to a Ghanaian case. Ageidum is AGYEITWUM versus Attorney General. It is a 2005-2006 case. SCGLR, not R, I'm speaking Afrikaans now. SCGLR, page 752. Let me summarize the essence of it, and you don't have to comment on it. Maybe in reply. It is this: Article 146, sub-articles 3 to 6 of the Ghanaian Constitution provides for a method to be a procedure to be followed in removing a judge from office and in removing the Chief Justice from office. As regards the judge, it says for anybody to petition the President to set up a committee that would look into the impeachability of a judge, there would have to be a prima facie case before further steps are taken. In other words, you must satisfy a committee of judges that there is a prima facie case. But for a Chief Justice, it's silent on that, meaning all you have to say is, listen, Mr. President, set up a committee, remove this person, and that's it, whether there is a prima facie case or not. Now, the Supreme Court of Ghana, which is the equivalent of this court, said a number of factors would have to be considered. One, you have to consider whether this is perhaps not one of the inadvertent gaps in the Constitution that must be filled. That is the first point. The second point is, in looking at this constitutional provision, we've got to check whether the underlying philosophy and core values of the Constitution point to the need to first establish a prima facie case or not, even if the Constitution is silent on it. And the third point is, you've got to be very careful about the literalist interpretation of the section. And four, it's important that purposive interpretation be given the weight that it deserves. That's the fourth point. And finally, whatever interpretation you ultimately settle for as a court, ask yourself a question, whether it does not perhaps lead to absurd consequences.
Absolutely.
So I'm raising it with you so that others can deal with it, and you can deal with it ultimately. But as you deal with it, remember that they were not there considering matters that fall squarely within the powers of Parliament. It was not a situation like ours where you have to, it is within the powers of Parliament to do something about it. But that said, when there is a thought or a belief that Parliament has not done what it is supposed to have done, is it permissible to bring that matter to the court and say, here is the Constitution. We are not asking you to do what Parliament is supposed to do. We are asking you to tell us the meaning of this section. Does it fall within our powers to say, this is the meaning, without saying to Parliament, now, we are hereby ordering you to do X, Y, Z. We are just saying, this is the meaning. The meaning is either you have no choice but to hold the to conduct the ballot openly or secretly, or it's never permissible to entertain secret ballot. Can we interpret at least up to that extent? Or, as you seem to suggest and others, should we even take it a step further and say you are hereby ordered to do X, Y, Z without trenching separation of powers? But
yes,
I want you to take time and reflect on it and then respond later.
I will do so in reply, Chief Justice. Safe to say the following. If indeed we are dealing with what in that case is called a constitutional gap, then may I make this proposal? The court doesn't have to decide this, but it's just to extend the logic of interpretation. My submission would be that in the parlance of that case, here in this country, we actually have a situation which differentiates between those two situations. Section 89 of the Constitution says that if there's a prima facie case, to paraphrase, of a breach of the Constitution and so on, then the President, by a vote again, should be impeached. And in my respectful submission, every submission I've made now applies.
But that would be 2/3, isn't it?
Yes, that's the only difference, which is not relevant for current purposes. But a vote in my respectful submission in that section is the same as this. The only difference with this 102, because it's a removal is a removal. The only difference is that in section 102, you don't have to establish any wrongdoing. They can just wake up one day and say, look, because of the junk status, as they've done now, we seek to remove you.
But you don't lose your benefits.
Absolutely. The two differences is the 2/3 and you don't lose your benefits. But it's exactly the same. The words are ringingly the same. The words that are used in section 89 are by a majority of a vote, or rather by 2/3 of a vote. In section 102, it's by a majority of a vote. In part 3 of the schedule, it says a vote by majority. So the words a vote, and that's just another rule of construction. If the words a vote are used throughout the same instrument, then at the very least we must assume that they carry the same impact. But my preferred approach, Chief Justice, with the greatest respect to this thing, is to ask the rhetorical question: why was the secret ballot prescribed? It must have been prescribed to protect the integrity of the outcome of the election. Do we want to protect the integrity of the election here? Yes. What is the answer? The secret vote. That can only be, and then to turn it around is to say, why would we have a vote, quote unquote, by a method that will render that whole exercise useless? So-called party discipline, which is invoked, simply means that in the words of the Mazibuko case, it would be within the gift of the majority party as to whether the vote succeeds or not. And that must be undesirable constitutionally, as it was stated.
It's not so-called. As I understand, I think, is it Mr. Semenya, he says, in fact, a number of parties, including the one you represent, have the same position in its constitution in relation to not voting as instructed. Can list a number of them. Yeah. If you don't vote as instructed, there are consequences.
Well,
but that was just by the way. I'm just saying, I'm addressing the so-called.
The same rules apply. Let me address it as follows. Well, if that is the case, well, bad luck to them. It means their constitutions are unconstitutional. It's a contract. We cannot equate a contract between private parties in a voluntary association with the constitution of a country, with the greatest respect. So any party can wake up and have a constitution that says, for you to be a member of this party, you must go and stab people. That's their business. But as soon as that encroaches on the Constitution, in fact, to put it mildly, what President Motlanthe said, which is that it would not be misconduct, what he really, what I interpreted to mean is the following. If a person was expelled under those circumstances.
Sorry, Mr. Mbo. He hasn't filed any affidavit.
Fine.
Please.
But it's in the papers.
No,
okay.
Please. There are a number of things in the papers that are not properly authenticated.
Right. Let's then do it in abstract.
Please.
If such a party, Chief Justice, were indeed to expel a person, and that person can come here and say, I was abiding by my oath of office, the result must be obvious. Because the party discipline story, that is its fault line. The oath that is taken, when those people stand up there...
Mr. Mpofu, sorry to interrupt you.
Yes, Justice Foreman, sorry.
I just want to know what is the relevance of the content of the constitutions of political parties to the issue in this case?
The only relevance is, the relevance is to the question of so-called, insofar as so-called party discipline has been invoked, because party discipline is another word of saying party discipline is the Constitution.
How does party discipline come into the interpretation of the Constitution?
It comes as follows. Section 1D of the Constitution says that ours is a multi-party democracy. In the Ramakatsa case, it was then that notion was expanded to say the vehicle through which citizens...
I'm sorry, just explain to me, how would it be different for us in deciding this constitutional question if the party's constitution did not have any disciplinary measures following upon this, or if it does? How does it make any difference?
It doesn't. As I say, it's just a contract, a private contract, and it cannot implicate as far as the remedy is concerned.
Before you get to the remedy, Mr. Mpofu, I thought that following on the list that the Chief Justice gave earlier, and the recent case in Ghana, also following on the question by my brother from a man earlier relating to parliamentary oversight, I thought that you'll go straight to what Mazibuko tells us in relation to how you read Section 102 of the Constitution. Let me take you quickly to those paragraphs. In paragraph 42 of Mazibuko, this court said the following: Section 102 must be understood Mazibuko.
I'm sorry.
Section 102 must be understood also in light of other related provisions, and one of them is Section 1D of the Constitution that talks about the multi-party system, but you have to go further, that it deals also with the need to ensure accountability, responsiveness, and openness. The other provisions is Section 57(1)(b) of the Constitution that also provides for a participatory democracy, accountability, transparency, and public involvement. Now, in this judgment, the court says significantly Section 42(3) of the Constitution provides. I'll read that provision. The National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the president, by providing a national forum for public consideration of issues, by passing legislation, and by scrutinizing and overseeing executive action. Emphasize by overseeing executive action. Now, the relevant paragraphs that I'm going to read, I'd like you to bear them in mind when you reply later, and also the other counsel, if they can address us on the issue of the effectiveness of parliamentary oversight over the executive when you deal with issues relating to the voting by the issues of motion of no confidence. Now, in paragraph 43, the court says the following, and I think it is pertinent. In the first instance, the Assembly is elected to represent the people and to ensure government by the people under the Constitution. A motion of no confidence in the President is a vital tool to advance our democratic hygiene. It affords the Assembly a vital power and duty to scrutinize and oversee executive action. The Constitution does not set a time or preconditions for when the Assembly may vote on a motion of no confidence in the President. The ever-present possibility of a motion of no confidence against the President and the Cabinet is meant to keep the President accountable to the Assembly, which elects her or him. If a motion of no confidence in the President were to succeed, he or she and the incumbent Cabinet must resign. In effect, the people, through their elected representatives in the Assembly, will end the mandate they bestowed on an incumbent president. The last part. The right that flows from Section 102(2) is central to the deliberative multi-party democracy envisioned in the Constitution. It implicates the values of democracy, transparency, accountability, and openness. A motion of this kind is perhaps the most important mechanism that may be employed by Parliament to hold the executive to account and to interrogate executive performances. I close quote.
Yes.
Now, as we interpret these provisions, having regard to what I've read to you, having regard to the constitutional imperatives relating to the effectiveness of parliamentary oversight over the executive, and also taking in mind what the Chief Justice has just read to us about the Ghanaian Constitutional Code, given the fact that we may find that the rules do not make provision for motion of confidence by way of secret ballot, is it not open to us to interpret the Constitution purposefully, having regard to all these constitutional imperatives, to find that the Speaker does have a discretion?
Yes. The short answer is yes, Acting Deputy Chief Justice. But more importantly, my learned colleague, Mr. Maineche, for the Institute for Security Studies, will deal with what I've dubbed the doctrine of effectiveness, which is what one of the things you have raised. But let me just say this. If we all agree, as we should, that this is the most vital tool and all the words that are used in Mazibuko, then on the other extreme, we can then jump in our interpretation thereof to literally making it toothless and all the other adjectives that have been used. In other words, when this court, with respect, interprets that section, it will have to take into account, this is the same as what Justice Cameron was alluding to. What was said in Makwanyane is that the Constitution elevates the right to life. In fact, Chaskalson and I think O'Regan J said the right to life and the right to dignity are rights which are elevated to a particular plane. And therefore, in interpreting the Constitution, that has to be taken into account. Again here, if this is the most effective tool and so on, then in interpreting it, the court, with respect, must then make sure purposively that it looks at the purpose of the section, one, but also what I said earlier, the purpose of the protection of a secret ballot. What are those two things telling us? The purpose of the section, it must give us the best accountability, the most accountability, the qualitatively speaking. But so on the one hand, but the purpose of the Constitution bringing such a thing as a secret ballot is to protect the voters from the potential of blunting, rendering toothless, ineffective, and so on, that very vital instrument. So I agree that the interpretation must take into account two things. One, that in Mazibuko, the court accepted that it is the members and not, in fact, the court articulated in those words, it is the members and not the political parties that must determine. So that must mean, in the context of the oath, that when those members have taken the oath to say, we will uphold, not we, Dalimpofu, will uphold the Constitution and so on. The minute they do that, then they are saying what they're going to be doing is going to be according to their conscience. Those who are religious take the oath, the others take the affirmation. Both are saying the same thing. Our conscience is going to guide us and nothing else. Not what the views of our church, not the views of our political party, not the views of this one or that one, but our conscience. And to give meaning, literally, to give meaning to that, we are humbly saying to this court, in fact, you cannot give meaning to all that without having the secret ballot.
You are 3 minutes short of 2 hours addressing us. I know that we put a number of questions to you, but shouldn't you leave it there? We've got your submissions.
Yes. Can I just round off as follows, Chief Justice? Just to reiterate what is, if then we all agree that this is simply a question of interpretation, what meaning to be given, then in reply, if issues of, those issues of intimidation, separation of powers, substitution and all that only arise in the alternative submission. And I will then deal with them insofar as any of the parties, because there is that confusion that I referred to. I would prefer to deal with them in reply. As the court pleases.
Thank you very much.
I'm indebted to the court for the audience.
Thank you very much, Mr. Mpofu. Thank you. Mr. Ngugaitobi, we're going to take a tea break for about 15 minutes.
Yes, Chief Justice.
Thank you. The court will adjourn.
All right, and there you have it. That's a tea break at the Constitutional Court. Chief Justice Mogoeng giving the go-ahead for the tea break. Following arguments from the United Democratic Movement representative Dali Mpofu, who basically is arguing that secret ballot should be allowed in Parliament, this ahead of that vote of no confidence in Jacob Zuma. We'll give you all the details as to what happened in court this morning, try and cross over to the court scene both outside and inside when we come back. A quick break now. Eskom there. Cheerful.
Bobby, and I take it our undertaking stands. We're not leaving until everybody has been heard.
Yes. Now
There's no tomorrow.
Mr. Mpofu took 2 hours instead of an hour. I have 30 minutes, so I wonder if that's an indication of how much time I actually have. Chief Justice, could I start by firstly explaining that we largely agree with the UDM. In fact, we agree fully with the UDM. And I just want, in the time that I have, to develop 3 topics that Mr. Mpofu didn't have time to develop. So the one is around the structural interpretation of the Constitution. The second is around the question of the discretion that the Speaker had. And then the third is the question of the remedy. And might I say upfront that the remedy that we propose is that the court itself should decide not only that the Speaker had a discretion, but that on the specific facts of this case, a secret ballot was warranted. So it is not a matter of remittal, but it is a matter of complete substitution. So that sets the framework of what I propose saying this morning. So firstly, let's delineate the outer limits of the discussion on the structural question about how the Constitution ought to be interpreted. So the starting point, and I think this is a point that Justice Ngabinde makes, is reference to Section 42 of the Constitution, particularly the obligation that is imposed on Parliament. So according to this section, particularly Section 42(3), there are 3 functions that are assigned to Parliament. So it is to choose the President, it is to provide a national forum for public consideration of issues by passing legislation, and then here is the important one, scrutinizing and overseeing executive action. This case is ultimately about overseeing executive action. And we know this from the Mazibuko judgment. We know that a motion of no confidence in its nature is a form of holding the executive accountable. In fact, I think Justice Museneke in that case says that it is the ultimate form of holding the executive accountable. So this is an important entry point into the case, is to understand the nature of the function that the Parliament is being asked to perform. It is a function of holding the executive accountable, scrutinizing their conduct, overseeing their conduct, and ultimately, when they fail, putting them out of office. Now, the reason why this is important to highlight upfront is because it illustrates quite clearly the sort of tension that our learned friends for the President, I think, referred to. And we don't criticize them for highlighting the tension because it is a real existential tension. And this is a point that is made also in the UTM case and also in certification. That sometimes there is a dictate of the party. The party wants its members in Parliament to behave in a particular way. But the members of Parliament are bound by the Constitution to follow certain rules. Now here, it is the most illustrative instance where a party that is the majority in Parliament must oversee its own representatives in Parliament. So here we see at its most extreme form why the duty imposed on members of Parliament, members of the National Assembly, why that duty becomes most profound. So we're dealing not only with the ultimate form of holding the executive accountable, but also with the point that illustrates precisely the point at which the clash between a party loyalty or a party mandate and the duty towards the Constitution arises. So here we say if the court is to adopt an interpretative approach, it is quite clear that there is no choice. Because the Constitution imposes an obligation on members of the National Assembly to hold the executive accountable, here they have no choice but to follow the Constitution. So that's the first point that we say is vital to point out. It is the significance of Section 42 and the imposition on members of the National Assembly, and how that imposition ultimately trumps all considerations, including considerations about party discipline. The second point that we must frame in relation to the structural construction of the Constitution is the entitlement or the right. Mr. Halter will develop the right around Section 19. I'm not going to argue the case on Section 19, but inside the National Assembly itself, members are entitled to vote according to personal conscience. That has now crystallized into a constitutional principle. We know that from at least 3 decisions, 2 of this court and 1 decision of the Western Cape High Court. So the first decision that illustrates the point that members of the National Assembly are entitled to vote according to personal conscience is the certification case, particularly paragraph 186. The Chief Justice and the members of the court will recall what was at stake in that case. It was a question about whether or not it was proper for the Constitution at the time not to provide for anti-defection. The criticism was that the idea that a member of the National Assembly may not defect from their party ultimately makes them subservient to the whims and the idiosyncrasies of the party. And the court finds that that is not so. The fact that a party nominates a member to sit in Parliament does not take away the discretion of the particular member on any topic before them to vote according to personal conscience. In fact, the question is answered in very unequivocal terms. An individual member remains free to follow the dictates of personal conscience. So we know it to be a matter of constitutional principle that each and every member in the National Assembly, regardless of the wishes of their political party, may vote on any topic according to their personal conscience. And the second judgment is Fetcho. Admittedly, Fetcho dealt with the local legislative sphere as opposed to the national legislative sphere. But Fetcho makes the point clear in paragraph 41 of Fetcho, where it says each member is entitled to his or her own reasons for voting for or against any resolution and is entitled to do so on political grounds. So each member, of course, may take into account the wishes of their political party, but remains, in a sense, autonomous to decide what to do on a matter that is presented before the local legislative assembly. The same principle applies in relation to the National Assembly. And then the final judgment is Van Zyl, which we cite in our heads of argument, and where, again, the point is made quite clearly, and there it was a motion of no confidence in relation to one of the members of the provincial legislature, where the court says it is recognized that the individual members thereof, individual members of the party, retain the right to follow...
Where are you reading from? Just which paragraph?
Sorry, Chief Justice, it is paragraph 45. The judgment of Van Zyl, I can't remember the judge, I think it's Van Rienen. But what he says is that it is recognized that the individual members thereof retain the right to follow the dictates of their own conscience. Viewed from that perspective, the vote of any individual member constitutes an articulation of his or her own view of how the question posed in the motion should be responded to. We've looked at the heads of argument filed by our learned friends for the President and the Speaker. There is no counter to the proposition that members of the National Assembly are entitled to vote according to their personal conscience. And there's no answer to any of these 3 judgments that we've cited. Then the third proposition that I want, in addition to Section 42, and as well as the entitlement, the right to vote according to personal conscience, is the duty, the obligation. And the duty or the obligation of members of Parliament is primarily to the electorate and to the Constitution. So that is their primary duty. That duty is most pronounced when one deals with holding the executive accountable, particularly if you are a member of the majority party. We know this, we've already referred to Section 42.3, but we also know it from the affirmation or oath that is taken by the members, because there they affirm to obey, respect, and uphold the Constitution. We also know this, and this is, I think, a point that is made by Mr. Katz, from the preamble of the Powers and Privileges Act, that the intention of that act is to protect the authority, independence, and dignity of the legislatures and their members. And we also know it from the Ngandla decision that was penned by the Chief Justice. So we know at least three things that should form the subject matter of the discussion. We know the entitlement of the members to vote according to conscience. We know that they not only are entitled, but they are obliged to do what the Constitution requires them to do. We know that they are not subservient or machines to carry out party mandates. In fact, their duty is agents to serve the public. When one interprets the Constitution, and this is the point I think Justice Froneman raised with Mr. Mpofu, when one interprets the Constitution, one must do so in order to fulfill these three principles that I have referred to. Or at the very least, one should not adopt an interpretation to the Constitution that will frustrate the ability of members to vote according to conscience, or that would frustrate the ability of members to hold the executive accountable. And that applies whether one is a member of the EFF or whether one is a member of the ANC. The fact of the matter is that one cannot adopt an interpretation to the Constitution that will not make it possible for members of Parliament to perform their primary constitutional obligations, which is to the Constitution and to the public as a whole. So the construction then that one places on the question of whether or not the Speaker had a discretion is a construction that must be consistent with the overall purpose of the Constitution. And these are the two primary, most important purposes of the Constitution that I have already set out above. So, what do we then say about the question before the court? So we say that on the issue of the discretion, the Speaker is clearly mistaken when she takes the view that she has no discretion to allow voting by a secret ballot. And it does not matter, Chief Justice, that at the time she made the decision, she was bound to follow the the full bench judgment in Taumana. Because the fact of the matter is that the court must look at the law objectively and make a pronouncement on whether or not, as a matter of constitutional interpretation, the Speaker does have a discretion or doesn't have a discretion. So we submit here that it's clear that the combined effect of Rule 103 and Rule 104, that the Speaker is entitled to decide the procedure that must be followed in relation to a voting, in particular, a no confidence voting in the President. Now, what that leads us to is, of course, Section 102 of the Constitution. Because here there is an issue about, well, is there an exclusion? It is clear, according to certainly the submissions made by Mr. Mpofu, that there is no exclusion. What is an omission. But the question of how one engages with that omission is a question of structural interpretation of the Constitution. And the structure follows the purpose, and we've already set out what the fundamentals of that purposes are. So, in other words, this is not a discretion in the air. This is not a discretion to allow a license for a liquor trading license in a township. This is a discretion to enable members of Parliament to perform particular functions. It is not a discretion to do whatever the Speaker wants to do. It is, in a sense, a limited form of a discretion. So the Speaker, it is true, has a discretion, but that discretion must also be understood in the context. I think we cited it in our heads of argument, in the first set of our heads of argument, in paragraph 8.1. The Speaker's discretion is a discretion that enables her to enable the National Assembly to allow the members of the National Assembly to perform their functions under the Constitution. So what is critical in paragraph 8.1 of what we say in our heads of argument is that Section 26 of the National Assembly rules, and this is what we cite here, it confers a number of obligations on the Speaker. The first one, in exercising the authority of the Speaker...
I didn't hear the section, and your 10 minutes
26, is up. 26, Chief Justice. Yes, sorry, I had forgotten that I had put a stop to my interrogation, but yes, I have no difficulties, unless it doesn't seem there's a question yet. So it's Section 26 of the National Assembly rules. What it provides for in Section 26.1, in exercising the authority of the Speaker as provided for in the Constitution and legislation and the rules of Parliament, the Speaker must, and this is A, ensure that the National Assembly provides a national forum for public consideration of issues, passes legislation, and scrutinizes and oversees executive action in accordance with Section 42.3 of the Constitution. So what we see from Rule 26 is a domestication of the broad constitutional obligation that even when the Speaker exercises her discretion she must do so to enable the...
Really, where does this discretion come?
Form of rules. They have already decided the rules. The rules themselves allow them the discretion. And Rule 103 and Rule 104 allows them the discretion. Rule 26 prescribes what the purpose of that discretion is. It's not a discretion in the air. So we submit that if the court explains to the Speaker that she has a discretion, the court does no violence to separation of powers. The court does no violence to Section 57 of the Constitution, because the court recognizes that insofar as that internal authority of Parliament, Parliament is king. But insofar as what that means, the judiciary is king. Now, now we know where we stand, that not only does she have a discretion, because it's explicitly provided for in Rule 103 and 104, we also know what the purpose of that discretion is, because we see that from Rule 26, that the purpose of the discretion...
Let me understand the discretion. I'm sorry, Mr. Dobi.
Yes, Chief Justice.
Are we to accept that the Rules Committee reflected on but decided against secret ballot in relation to motions of no confidence?
No, Chief Justice, we simply cannot...
We are not to accept that.
No, we must reject the proposition.
Okay.
It is a proposition founded on the text.
Yes.
To the contrary, what the text ultimately does is to leave the question open.
No. I'm asking a slightly different question. My understanding of the Speaker's position is this, that political parties represented in the National Assembly had occasion to reflect on whether to make provision for a vote by secret ballot when either a motion for impeachment is considered or a motion of no confidence is considered. I'm asking whether that is to be accepted as a fact. Did that actually happen or not?
Chief Justice, we should reject it if the only evidence... Sorry, Chief Justice, it looks like you have a follow-up question. Sorry. If the only evidence is manifested in the rules, and I make the argument that ultimately the National Assembly functions through the rules, if the only evidence is manifested through the rules would have obviously prohibited a voting by secret ballot. On a proper construction of the rules ultimately leave the question open. But we cannot accept that by implication there has been an exclusion in the rules themselves.
I'm not there. I'm elsewhere. I'm saying, did occasion arise where where political parties represented in the National Assembly asked themselves a question? Isn't it necessary to make provision for voting on a motion of no confidence against the President by secret ballot, but that did not materialize?
No, Chief
because
Justice.
then that would lead to another question, which would be, how can the Speaker then find it possible to go against a position that she knows the collective has rejected?
Yes.
But if you tell me that we are not to have regard to what she says, it's not correct, I'm happy with the answer.
Yes, it is incorrect, Chief Justice. I think I now understand the question. It's been asked 2 times, so at some point I must come to the understanding. So, on the first point, Chief Justice, we should reject it. I mean, there is nothing on the evidence that shows, that proves that point at all. Yes. The Chief Justice presumably understands my primary argument that on the construction of the rules, the question is ultimately open. But it is not open-ended because of Rule 26 of the National Assembly rules.
Would we arrive at a conclusion based on the rules, regardless of what we understand the Constitution to be requiring of the National Assembly,
yes,
or the Speaker? Or is our starting point Section 102.2?
Yes.
And only thereafter can you begin to say, because this is what the Constitution means, Properly understood, this rule then means this.
Yes, Chief Justice, that's correct. And this is now the next point I want to deal with, which is this. The points we've made about the entitlement to vote in accordance with personal conscience, the point we have made about Section 42, all of those factors play a role in how to interpret the rules and how to interpret the conduct of the Speaker. But then there is Section 102, and this is now my next point. It's Section 102 that deals with the question of the removal of the President by way of a vote of no confidence. So the starting point here is not to make, and I think the point is that we are being accused of making a linguistic jump between Section 102 and Section 86. When we cite Section 86 of the Constitution, I now make the textual argument. When we cite Section 86 of the Constitution, we don't ask the court to superimpose the procedure in Section 86 in place of Section 102. What we say are three things about the significance of Section 86 and the procedure that it prescribes. The first is that the constitutional text itself contemplates that in the event of a contested election of a president, that contest must be resolved by a secret ballot. The second point that we make is that the sole justification, we have not seen anything in our learned friends' answering affidavit and in their heads of argument, contesting the suggestion that the sole justification why the contestation of the election of a president must be conducted by a secret ballot that is not intended to protect the personal conscience of the members of parliament. If members of parliament are entitled as a matter of law to vote according to their personal conscience, the only logical explanation why Section 86 requires a contested vote of a president to be done by way of a secret ballot is to protect the personal conscience. No contest is taken with that proposition at all by our learned friends. The third reason, and this is the reason that Justice Cameron was texting Mr. Mpofu about, the third reason is the inseparability between the office of the president and the person occupying that office. Why members of parliament must exercise their independent judgment to bear is because not only should they simply take for granted whoever is proposed by the majority party, but they themselves must reflect whether or not the person who is about to be entrusted with the most important office in the country is in fact suitable. And from that perspective, they are entitled to then bring their own independent judgment to bear. We know this, the point that Justice Cameron judgment, Chief Justice, in Gandla, in paragraphs 20 and 26, where the Chief Justice explains what the responsibilities, and perhaps if I could cite in paragraph 20, the President is the head of state and the head of the National Assembly. He is indeed the highest calling to the highest office in the land. He is the first citizen of this country and occupies a position indispensable for the effective governance of our democratic country. Only upon him has the constitutional obligation to uphold, defend, and respect the Constitution as the supreme law of the Republic has been imposed. So what we see from Section 86 is that the logic why Section 86 specifically says once there is a contestation, you must now be free to exercise independent judgment, also implicates the personality of the president and not just the mere fact that they have come from a particular political party. And so what we say then from that comparison with Section 86, we obviously don't make the language leap that Section 86 must simply be imposed. But what we say is that the logic underlying Section 86 applies with equal force to Section 102 of the Constitution. What members of Parliament are now being asked to do by the UDM, or I think the DA also has made this proposal. What they're being asked is you must decide, apparently the IFP has done the same. What they are being asked is that you must decide a most contentious question. Is this man fit to remain in office? What they are being asked to do is that they must do so by reference to their personal conscience. What they are being asked to do, as according to Justice Museneke, is that they are being asked to decide on the ultimate form of holding the executive accountable. So one can never separate the question about the personal integrity of the man occupying the office from his constitutional obligations. So in those circumstances, we say there is at the very least a comparable scenario, because once one accepts the logic beneath or behind Section 86, one must inevitably come to the conclusion that in the event, as we have shown, that the rules are silent on the question or the rules are not exclusionary, the most logical way that promotes the value of holding the executive accountable and the most logical way that promotes the value of personal conscience of members of parliament is a secret ballot. And by the way, Chief Justice, the idea of a personal conscience, although it has been raised pertinently by the UDM, has in fact not been contested by the Speaker and the President. So, and I come now to my final point on this issue. So, Chief Justice, what we ultimately submit is that once one looks at the structure of the Constitution and once one looks at the of members of Parliament, also inevitable is that the only way that this discretion on these facts is effectively. And we are not concerned here, and I know the President criticizes us about this, we are not concerned here with the outcome. It does not matter whether or not members of Parliament ultimately decided to retain President Zuma. What we are concerned is the conditionalities that must be present for the effective exercise of personal conscience. And the argument that is being made is that the only conditionality that is not only constitutionally warranted, but also obligatory, is that the members of Parliament must be free to decide for themselves. Whether they are members of the ANC actually makes no difference. The fact of the matter is they must be free to decide whether this man is in fact the true embodiment of the spirit of the Constitution.
Why won't they be free otherwise? I haven't heard you touch on that.
For the reason, as truism, my suggestion, that in order to exercise personal conscience, you need some protection. From what? You need the protection from any possible repercussions of the exercise of your personal choice. And we know this open voting ultimately exposes each and every member of Parliament to these repercussions, which have not been hidden in this case. They have been explicitly pleaded by the President and are explicitly defended even in their heads of argument. So the only way members of Parliament can be able to be free to exercise their personal conscience is if there is a judicial protection to party repercussions. And that ultimately is at the center of the problem. And here we are asking them, by the way, Chief Justice, in fact, to act in fulfillment of their constitutional obligation, sometimes contrary to the wishes of the party.
We have regard to what the parties say would happen or what the President says might happen should members of his party vote differently, or should we rather base it on the known rationale behind a secret ballot?
Chief Justice, I would...
Because it, just to clarify my position, it seems to be a bit problematic to say the President says. What if he hasn't said that?
Yes.
It doesn't quite help us to articulate the principle if it's based on either a threat or some looming repercussions expressed by some senior official of the ruling party. Isn't it better just to say experience has taught, based on whatever you can rely on, that they are likely to be, there is a potential for consequences that are undesirable for want of a better expression, and therefore?
Yes. I accept the suggestion, Chief Justice, without qualification. And I won't do the usual lawyer thing of saying I accept it, but I have something else to add. That takes me then to my... okay, well, Justice Kambembe.
Are you presiding now?
I'm sorry, Justice Kambembe. Let's go back to the Chief Justice.
Thank you, Chief Justice. Mr. Ngugaitobi, the South African political system is based on the principle of accountability and transparency. Is it not anti-democratic to have MPs voting secretly?
Yes. Justice Kambembe, we don't ask for a permanent principle. We ask for a limited principle that on these facts that we have, that the court has before them, it's inevitable, the mistakes made by the Speaker, the impossible conflict that she currently faces on this particular set of facts, it is almost an inevitable conclusion that this kind of a vote must take place by way of a secret ballot. There is another question that you are raising, which is, well, what do we do about the future? Parliament might respond to this in a variety of ways. The one is that it might domesticate this court's ruling into its own rules so that it decides how it should deal with motions of no confidence in the future. And that is what Section 57 ultimately is about. And so the court does not have to answer the democratic question as such, because that democratic question is itself assigned to Parliament as the place where the Parliament decides for itself what is the best method of incorporating the principles of democratic participation and accountability. So to that extent, that is the correct space where that debate ought to be taking place. So we would submit that a limited decision on these particular facts, in fact, does no violence to the democratic principles of openness and accountability. Chief Justice, I think I can now pass the mic
Well, it's my brother Jafta's turn. Once he's done, I want a signal from him because I didn't.
Sorry. You commenced by drawing our attention to the rules.
Yes, Justice Draft.
And you moved to the Constitution.
Yes.
Would I not be correct to say the starting point should be the Constitution? And you may move to the rules if the Constitution is deficient in some respect. The reason why I'm raising this, I'm not clear on the basis of your argument as to where you locate the discretion. Is it in the rules? Is it in the Constitution interpreted in the manner that you have articulated, or is it in both?
Yes, I would suggest, Justice Chapter, that I'm asking for a combined, so on the starting point, I think it's just the way I presented the argument, but I accept your argument in terms of the hierarchy of interpretation. It's quite clear that one starts with the Constitution. But I start there as well. I start from Section 42 of the Constitution. I say we start with the object that the rules serve. The rules don't exist for themselves. They serve a particular purpose. So the purpose is Section 42. So whatever construct one places on the rules is a construct that not only must be consistent, but must also fulfill Section 42. And so here what we have is that where there is a linguistic gap in the rules, that gap will suggest that the court should in fact deal with it by way of interpreting what the object of Section 42 is, and therefore what the object of the rules ought to be in the light of Section 42. But then you ask me a second question, which is where we locate the discretion. I suggest we locate the discretion in a, sorry, just after, yes, I suggest we locate it in different places in the Constitution. I mean, earlier on, Chief Justice spoke about Section 55 of the Constitution, which is an important section because that was the section in which this court asserted its exclusive jurisdiction in relation to the EFF case. But it's important also because it defines the role of the National Assembly, because in Section 55(2)(b), the National Assembly must provide for mechanisms to maintain oversight of the exercise of the national executive authority, including the implementation of legislation. So the rules, in fact, are intended to be a mechanism to maintain this oversight. And if one looks at the rules themselves, so the rules must make provision for this. If one looks at the rules themselves, the text of the rules, clearly, I mean, if one looks at Rule 103(1), it says, unless the presiding officer directs otherwise. If one looks at Rule 104, with a procedure determined by the Speaker, and directives to be announced by the presiding officer. So,
at the level, I'm sorry to interrupt you, at the level of interpretation, what I want to appreciate is whether, when one follows the interpretative process that you have advanced, does one reach a conclusion that the Constitution itself read in context with Section 86, requires that motions of no confidence in Section 102 must be dealt with by secret ballot without adding the rules.
Well, what I suggest, Justice Chapter, is the rules are important insofar as the question of the discretion is concerned. The rules make it clear that you have a discretion, but I suggest that the way in which that discretion ought to be exercised is an important constitutional question. The way to interpret how that discretion is to be exercised is by then having regard to the Constitution.
Shouldn't then we draw a distinction between the genesis of the discretion and the manner in which it has to be exercised?
Yes, Justice Chapter, I accept that.
Is the genesis the Constitution and the rules regulate the manner of exercising it?
Yes, that is correct, Justice Chapter. Thank you.
If the rules were not there, what would you say?
Justice Mogoeng,
I know they are there, but if they were not there.
Yes. Chief Justice, well, there could be a number of, there are the more serious answers to the question and then the less serious answers. Maybe I should focus on the serious answers. So first, the Parliament has no choice but to make these rules. But I would suggest that even in those circumstances, on my structural construction of the Constitution, I would still suggest that if one looks at the logic behind Section 86, that logic equally applies to Section 102. I simply say that as a matter of pragmatism, the court need not necessarily reach a question which it does not have to reach to get to an outcome. There is a lower level way of addressing the question that is before the court, which is the discretionary argument, and the discretionary argument coupled with a substitution order. So if the rules were not there, I would suggest that the argument that Mr. Mpofu advanced is in fact a good argument for the reasons that he advances in relation to how Section 102 should be read together with Section 86.
Why do you want an interpretation that caters for the now and not for all times? And how do you get there? Why do you want a solution just to deal with this case?
Yes. Well, Chief
and
Justice,
not an interpretation that will always be available for whoever wants to move a motion to employ or to resort to?
Yes.
I don't understand this.
Well, Chief Justice, the interpretation I have advanced to the court is an interpretation for now and the future. Let's confront the problem. It's the interpretation for the now and the future. All I say is that...
I thought you said you're not asking for a permanent principle.
Yes, no, Chief Justice.
Is that not what you said?
No, on the interpretation, I suggest that I'm simply saying that the court does not have to decide other cases.
No, please let me just get this one right, because that's why I said once Justice Jafta is done, I would like to come back to you to this issue. Was it not the position you articulated that you're not asking for a permanent principle or a principle that will always be available to be resorted to in dealing with matters of this nature? You want a solution for the current problem. Is that not what you said?
Well, Chief Justice, that is probably what I said. I can't remember the exact words, but the Chief Justice...
The effect, is that was it to the same effect?
Yes, but let me just clarify, because now that I have a chance to clarify where I stand on the matter, I should. Now, Chief Justice, what I do suggest about the interpretation, it's impossible in any event to advance an interpretation that will apply to Mr. Jacob Zuma's removal, but not apply to Mr. Malema's removal. The fact of the matter is, or Mr. Musa's removal. Yeah. But the fact of the matter is that if I'm right in my interpretation, it will apply to everybody. But the distinction I'm trying to draw, maybe too fine a distinction, is that the court does not have to decide future cases in relation to how the Speaker's discretion might be exercised. And one can think of a number of instances that might arise.
Please allow me to interrupt you. Here is where I am, Mr. Ngukaitobi. I thought all we have to do is interpret the Constitution and, to the extent necessary, the rules, and say, this is what the Constitution properly interpreted means.
Yes.
This is what the rule or the rules properly interpreted mean. Whether you use them or not is none of our business. We're simply interpreting so that there is clarity in relation to the meaning of the section or the sections or the rules. That's it.
Chief Justice, I accept
So
that.
I wanted to clarify this permanent principle statement that you have made.
Chief Justice, I accept what you have just put to me. And insofar as I try to draw a separation between another set of facts, the fact is that those facts are not before us and they don't have to be entertained. So I accept the proposition that ultimately the court must interpret what the rules mean and it must interpret what the Constitution means. I have advanced an interpretation and its justification. And who uses it in the future is up to future generations.
Are you saying that the Speaker is permitted to have a motion of no confidence conducted by a secret ballot, or are you saying the Speaker is required to have a motion of no confidence conducted by a secret ballot? I'm not too, I think you're saying she is permitted, she may. I'm not too sure. I just want certainty as to what your submission is.
Well, I make two submissions here, Chief Justice. The first is that she is clearly permitted on the text of the rules. Once the text of the rules is subjected to my constitutional analysis, she is in fact obliged. And I'm asking the court to find that the Speaker was in fact obliged in this case to ensure that it was conducted by way of a secret ballot.
On which section do you hinge the obligation as opposed to the permissibility?
Yes, I hinge the obligation firstly on section 42(3) of the Constitution. I hinge it next on section 55(2)(b) of the Constitution. And I have referred to the jurisprudence of this court in relation to personal conscience, and I have also hinged it on the comparability of section 86 and the underlying logic of section 86 and read together with section 102. Our submission is that you have to read section 102 and schedule 6 together with section 86.
Mukajwabi, do you add to what you've just told the Chief Justice any specific facts that you want us to look at? Or are they abstract facts? Or are you going to get real down close, slow and dirty and tell us what you want us to take into account?
Justice Cameron, there are some facts that can be taken into account which are sort of in the middle between the abstraction and the real and the dirty. The one important fact is the supermajority enjoyed by the ANC, which is common cause. The second important fact is, again, the uncontested fact about the threat of party discipline. The third fact, which we say in our affidavit, is the fact that at least one MP has publicly said that she should not be required to follow an injudicious leadership. But she finds herself in an impossible bind because of party instructions. Those facts, excluding questions of intimidation, those facts alone are sufficient to enable this court to get to my conclusion that once one looks at these particular facts that are applicable here, and that's why sometimes I'm reluctant to anticipate what the future might look like, but I suggest that these facts show how heightened the obligation that is imposed of the
So you're really asking the court to say that the Speaker's discretion in the light of the constitutional imperatives and the structure of the Constitution you've set out is very narrow. If there's any situation in which the Speaker may have reason to suspect or fear that there will be dictation or intimidation, let alone threats, it's a very, very narrow discretion, a mere trigger, and the Speaker should say, we're going to have a secret ballot.
Yes, indeed. And I do suggest, Justice Cameron, that the Speaker might, in the light of this court's judgment, decide to make a specific provision. I mean, as someone was saying to me, in other jurisdictions, 20% is enough to trigger a secret ballot. But that is a different issue. But on these facts, that should have triggered a secret ballot.
I'm sorry, Mr. Ngwaitobi. Just for clarification, the Chief Justice just asked you about whether you say the Speaker is required or permitted to ensure that it's the secret ballot that is used. You have given a certain answer to that question, but that answer appears to me to be possibly inconsistent with the stance you announced when you started. When you started, you said you supported the submissions made by Mr. Mpofu. Mr. Mpofu said his primary argument was that the Speaker was required. His second one was that, as an alternative, the Speaker had a discretion. Does that mean there's been a shift on your stance, or is it the same thing?
Justice Sono, I'm trying to recall what Mr. Mpofu said. The last
when you stood up, you were quite clear about what he had said.
The last thing I want is to disagree with him. Justice Sono, I don't know what the consequences, but I suggest that the answer that I'm trying to give is as specific as possible, is that insofar as she says that she has no discretion, she's mistaken as a matter of law. I submit that it goes beyond a discretion. She is, in fact, obliged in this case. Now,
by the facts, you mean?
Yes, she is obliged by these facts and by the objectives that I have articulated to the court.
That I understand. I understood yet that to be your answer to the Chief Justice's question.
Yes.
But what it raised in my mind was that being obliged that you are talking about now is different from the being obliged that Mr. Mpofu was talking about. Mr. Mpofu was saying, if you interpret the Constitution properly, the conclusion you must arrive at is that the Speaker is obliged. If you are not with me on that, that's what he was saying, then my next argument is the Speaker has a discretion.
Yes.
But what you have just said doesn't seem to me to say exactly the same thing. And all I'm asking is clarification whether you just want to focus on the discretion or whether you are still also pursuing the Mr. Mpofu's primary argument as well.
Yes, thank you, Justice Sondo. I think I now understand. My primary argument was on the discretion, and I have used the text of the Constitution and the comparators to support the primary argument, and in particular to support the relief that it is inevitable, foregone conclusion that here she should have allowed a secret ballot. I presume Mr. Mpofu will have a chance to reply, so he can decide for himself whether I have agreed with him or I haven't agreed with him. So I'll leave it at that. Yes.
Mr. Ngugaitebe, would it be correct really to speak of a discretion? If the Speaker is obliged on the proper interpretation of Section 102, read with other sections of the Constitution, to have a motion of no confidence dealt with by secret ballot, can we term it a discretion?
Yes, I mean, when I commenced, Justice Chapter, I said it was a very limited form of a discretion. And I mean, I suppose it is simply the absence of the limited words that you can use in the English language, unlike in Xhosa. But it's an attenuated form of a discretion.
Is it a discretion at all? That's my problem.
Yes,
if the Constitution says, in order to serve the purpose of Section 102 and eliminate any potential risk,
yes,
the voting for a motion of no confidence must be by secret ballot. What discretion is open to the Speaker?
Justice Chapter, yes, I agree.
No, Mr. Ngugaitebe. On a lighter note, I thought I had experience. I've always experienced you as a man who speaks directly and with clarity. So I'm begging you to speak with clarity now. Is it reasonable to assert that the public vote, as permitted by Section 19(2) of the Constitution by secret ballot, to protect them from possible unpleasant consequences that could be meted out to them by those who were expecting them to vote for them, but now know that they didn't. Is it fair to say that? You're protecting, you don't want anybody to know that they didn't vote for this one, they voted for that one, therefore you protect them. Is it fair to make that assertion?
Yes, it is.
Right. Okay. Can I move on? Or
Yes.
I just wanted a yes, but if you want to articulate, I don't want to treat you like a pupil.
I need to hear what the question is.
Yes.
Yes.
All right. Now, is it fair to extend that logic or that rationale to voting for a president? Let me explain what I'm talking about.
You mean MPs voting for the president?
Yes. You see, when there is no other candidate, what are you wasting a vote for?
Yes.
There's no contestation,
Yes.
no show. So the presiding officer declares. But if there is more than one candidate, they may even be coming from the same political party,
Yes.
or a combination of those possibilities. And just in case you were told by somebody that you relate very well to or somebody superior to you to toe a particular line, it appears, broadly speaking, that Schedule 3, Part A, Item 6A, seeks to protect the identity of the voters.
Yes.
It shouldn't be known who of the many possibilities you voted for, so that you don't attract
Yes.
undesirable or unpleasant consequences.
Yes.
That seems to apply to that situation, isn't it?
That is true, Chief Justice.
Right. Let me take it a step further. Now, the choice in terms of repercussion, or the seriousness in terms of repercussions between, and that addresses the need to protect or the need not to protect, between voting for a person who's just entertaining a hope.
Yes.
He or she likes it,
Yes.
and is hoping to enter,
Yes.
but does not enter because certain people did not vote him or her into office. Contrast that with a person who's occupying now,
Yes.
sitting majestically there with all the power and the benefits and everything that comes with it.
Yes.
Now you want to drag the person out of the seat
Yes.
and out of the benefits. Where do we find more risk?
Yes. Chief Justice, you've spoken with even greater clarity than you know me to do. But Chief Justice, this is precisely the point, is that once one looks at the nature of the function being performed, it is not just an ordinary holding of the executive accountable.
No. Please answer my question. I'll follow with the rest.
Yes.
Where does the risk lie the most?
It lies the most in the removal.
In the removal.
Particularly because of the likelihood of the removal failing. And that is the problem at issue, because one never knows what the removal ultimately will achieve.
Right. Now, and that is because the removal holds a lot of humiliation, isn't it?
Yes, Chief Justice.
Not just for one person, but for a whole host of people.
Yes.
If it succeeds. It's humiliating. It's painful.
Yes. Indeed, Chief Justice.
It is the worst thing you can ever wish for your enemy, for want of a better expression.
Yes.
So why then is it a permissible as opposed to a required, I don't want to say option, method? Why is a secret ballot then, according to your primary position,
Yes.
permissible and not required? You see, when we sit down now to consider judgment, we want to have the benefit of your input. Why are you saying it should be a discretion and not something obligatory? You don't have to say it. I want to understand the logic.
Well, Chief Justice, I must give you my understanding of it. What we do suggest is that if this is a discretion properly so-called, I mean, one looks at the rules. The rules sort of contemplate a permissible atmosphere. But what we ultimately suggest is that there is absolutely no way in which the objects of the Constitution can be achieved other than by a secret ballot. And the Chief Justice has actually put the finger on the problem. What happens when this vote of no confidence fails? And this is the problem. The only way that the MPs can be protected in a manner that enables them to vote according to their conscience is a secret ballot. So insofar as you have a limited form of a discretion, which this is how I've termed it, a limited form of a discretion, it is a discretion that must be exercised in a particular way to achieve particular objects. And I've set out what those objects are. So I would contest this sort of open-ended nature of a discretion and suggest that if there is any discretion, it's a very, very limited form of a discretion. So that's as far as the question of the discretion. It's a limited form. Perhaps we can find another word for it.
To sum it up, your primary argument is that the National Assembly or the Speaker has a discretion, and your fallback position is that the Speaker is obliged. Am I mischaracterizing your position?
No, Chief Justice. What I do say is that the text of the rules, yes, the text of the rules do not prohibit. The speakers came to court saying, I'm prohibited, I have no discretion. The text of the rules do not prohibit. In other words, it's permissible. But I suggest that when one looks at the current case before the court, it is obligatory. And so I have no alternative argument on the current case before this court. My primary argument is it was obligatory, not just to permit, but to ensure that the voting takes place by way of a secret ballot. It was an obligatory requirement in order to fulfill all of these objectives of the Constitution. Sorry, what should I say? No, but I mean... the Chief Justice, I think I've said most of the things I wanted to say, and I think I've also been allowed more time than I was entitled to. Unless there are any pressing issues, I'm tempted to allow Mr. Katz to take over.
Thank you very much, Mr. Ngugaidobi. Thank you.
Thank you, Chief Justice.
Mr. Katz? Mr. Katz?
Thank you, Chief Justice. Chief Justice, in representing the IFP, the Inkatha Freedom Party, we submit that most of the questions that have seemingly exercised the court this morning have all been answered in our written submissions. And the IFP takes a principled stance as follows. Section 1, read with Section 102 of the Constitution, has the effect that the Speaker has no discretion, those sections properly interpreted. Every single motion of no confidence is to be dealt with by way of secret ballot as a matter of principle. The first principle that we talk to is Section 1, the rule of law. And the rule of law includes, as a proposition, separation of powers. And this court has said over and over that that separation of powers in the South African constitutional setting requires, it's not a choice, but it requires Parliament to oversee the executive. And when Parliament fails to do so, such as in Nkandla, this court will say so. So we disagree in a sense with Mr. Mpofu, who says separation of powers is not implicated in this case. It is. It's implicated at the heart of this case. And the heart of this case is how is the National Assembly to oversee the executive by way of, for example, a motion of no confidence, and as we've said in our heads of argument and in the IFP's affidavit, that needs to be effective and not toothless by way of a secret ballot. So that's our starting point. I want to deal with 4 topics with the rest of my time, sort of the start and the end of our argument. The 4 topics are, in paragraph 5 of our written submissions, we make the point that this case must be determined not with reference to facts, such as whether President Zuma is good, bad, or indifferent, not whether the ANC intimidated its members. Those are irrelevant. Similarly, the rules of Parliament are irrelevant for purposes of this case. The only fact that we do wish to turn to, which is a fact that will go to 2 aspects of this court's consideration, is, and that those 2 aspects are, 1, this question of direct access, the preliminary point that was debated earlier, and secondly, remedy, are the facts relating, and I do want to ask the court to focus on it, how the IFP have dealt with motions of no confidence over the last 7-8 years. And on pages 223 and 227 of the record, in paragraphs 12 to 24 of the IFP's...
Page reference?
223 to 227. Perhaps I should just ask the court to flip to it very quickly. On page 222, there's a heading, the IFP's historical and current position in regard to the issue. And then one sees a series of paragraphs in which IFP members, the Chief Whip, the lead, that's various other members of the IFP, members of Parliament, Mr. Ambrosini, Mr. Dandladla, Mr. Koos van der Merwe, who was then the Chief Whip, Prince Buthelezi, and more recently, Mr. Naran Singh, who's the current Chief Whip, all complained to the Speaker during various times that motions of no confidence should be dealt with by way of secret ballot. And the response from the various speakers to the IFP was silence. That factor will influence the court somewhat in 1, whether to grant direct access, and 2, the nature of the remedy that this court may grant under section 172 of the Constitution. So when I suggested that the facts relating to intimidation and otherwise are irrelevant, this fact of the IFP's long history of advocating for the matter as a matter of principle, not relating to particular facts, we say should have some relevance to this court's consideration. Turning to the next important aspect is the unemployed people's movement, the second amicus, makes what we would suggest are compelling arguments why this particular secret ballot, this particular motion of no confidence should be dealt with by secret ballot. But we, in our written submissions, in paragraph 44 and following, and in particular in paragraph 46, deal with all the points raised as to why this court should not only go to the coming up motion of no confidence, but should deal with all motions of no confidence as a matter of principle. And there are a range of reasons why we suggest that, and we'd like to turn to those issues. We say in paragraph 45 that it would be not appropriate or desirable, and we would emphasize the interests of justice for this court to avoid the question as to the broad principle about as whether all motions of no confidence should be done by secret ballot. As an introduction to that debate, we should make 2 points. The first is that motions of no confidence are constitutional motions. Unlike other motions that come before the Assembly, this particular motion is contemplated and dealt with exclusively in the Constitution. Secondly, were we to be wrong in our primary submission that the Speaker does not have a discretion, the interests of justice, we would submit, would not be fueled when it comes to the question of how many times would the Speaker be taken on a review. The courts would be flooded with cases of the Speaker getting his or her discretion right or wrong on a case-by-case basis. So we would submit the interests of justice lead up to this court deciding the issue for once and for all. Are motions of no confidence properly interpreted, ones to be dealt with by way of secret ballot or not. In paragraph 45.1, we say, 1, we accept that there's no express equivalent. And Chief Justice, as Mr. Mpofu was arguing this morning, we took comfort from your suggestion of what we call the Ghana point, where the 3 reasons...
No, that was just the thinking aloud. It's not a suggestion.
Well, but the thinking aloud led us to the conclusion that there are 3 reasons why, despite the fact that there's no express inclusion of a secret ballot in 102, properly interpreted, it does include a secret ballot. And the 3 points: 1, the purpose of an approach to interpretation. So the court is interpreting the Constitution, nothing else. No rules, it's irrelevant. We know that the Constitution can't be given effect to by whatever the rule says. That's an old, long-standing principle from Moodley prior to the Constitution, etc., by the then Appellate Division. 2, the fact, like in that case, in the Ghana case, it would be absurd. There, the Ghana court held to have a lower threshold than prima facie for purposes of referral of the judge. There, the judge would be referred to a commission, and there had to be a prima facie case against the judge. It would be absurd not to have the same prima facie threshold in respect to the Chief Justice. We say similarly, when it comes to electing the President, when there's a contested vote, and for all the reasons that I think Justin Cameron put this morning, Chief Justice, you put to our learned friend a few minutes ago, it would be absurd to have a secret ballot in electing a president in a contested case, but rather not when he's potentially being removed. And thirdly, the point that's made in the Ghana case, the broader constitutional scheme. I think Justice Fruneman spoke of it this morning. So for those 3 reasons, we say, despite the fact that an express provision dealing with secret ballots is not included in Section 102, those 3 reasons suggest that's an irrelevant. 45.1.1, it's important we make this point, and it follows through our whole argument. The secret ballot removes the potential. It's not the question of whether there is a threat, but it removes the potential for threats. And we've referred to the notion of the sword of Damocles hanging over, well, it's a sword that was hanging over Damocles, who, in my Greek mythology, is not great, but perhaps the court could have regard to what actually happened there. The question was, when the person sat on the king's throne, there was a sword, and the sword hung over the king's head in case he abused his wealth or power. This was the sword. And our sword, our South African sword, is a motion of no confidence. That where there's a person, in that case the king, who has wealth and power, and it can be abused or otherwise, there needs to be a sword to say, King, better watch out. There's something that's going to hold you accountable. But that sword needs to have teeth. And the teeth that it must have is a motion of no confidence, which can be legitimately, fairly, and properly debated and voted on. And if it cannot be, because there's no secret ballot, the sword has no role to play. 45.1.2. Importantly, and this ties into Mr. Unterhalter's argument, it removes the Hobson's choice faced by members, and it says of the majority party, but it's not necessarily the majority party. Perhaps we should qualify our heads in that respect, who wish to vote in favor or against it, who may lose their seats or lose their position in the party. It shouldn't be a Hobson choice. They should be able to, every member of parliament should have a free vote, in the sense that they vote according to their conscience, according to what the Constitution demands. Then we, in 46.1, and we would ask the court, we'd emphasize the various aspects as to why we say the unemployed people's movement are wrong to only focus on this. But we want to pick up on a question that Justice Kampepe raised this morning, and that was this. The question was, why should there be a secret ballot when one of the founding principles is openness and transparency? And wouldn't there be a clash of some kind and an override on the question of openness and transparency over the question of secrecy? And the way we've dealt with it, in a sense, is paragraph 46.4. But our entire heads say we accept that there may be a clash of these values. But we say, were a secret ballot to always be the case in a motion of no confidence, the question of accountability is strengthened. And we say, in paragraph 46.4, perhaps I should just read what we say. Any potential for instability following a closed ballot is offset by the corresponding and equally serious instability which may occur if the potential for a motion ceases to be an effective check and balance on the executive conduct. Then the next sentence, this openness, Justice Kampepe, has the potential to undermine the legitimacy of government and to render toothless this important constitutional limitation on executive power. So what we say is this: to the extent that openness is a value to be strived for, it must also be strived for within the bounds of having an effective separation of powers, by having an executive which is subject to accountability. And to have openness may well compromise that very founding value of the Constitution, accountability. And that's the clash that perhaps can only be, we would submit, only be resolved by a secret ballot in all cases. And we emphasize the last sentence in paragraph 47, where we say, this court, it's numerous cases, Mazibuku case, certification case, has remarked the importance of a motion of no conference to the proper functioning of South Africa's constitutional democracy cannot be gainsaid. It is an enshrinement of the separation of powers and limits the power of a single individual or institution, and to make the branches of government accountable to one another. So when we take those values that this court has so majestically described on numerous occasions, and we apply it to the interpretation of Section 102, the only conclusion that we would submit the court can legitimately come to today is that all motions of no conference must be held in secret. So we want to come to remedy.
Before you do, let me just raise something that keeps on bothering me, and I don't know what to make of it. It is not only when a motion of no confidence is to be considered that the need for accountability arises. It arises when ministers have to come before portfolio committees, before an open session, and there is no room for you to duck and dive there. How then do you link the openness of the debate to the need to ensure that there is accountability at all times? Does it only relate to the president? Does it not relate to the ministers and the directors general when they come? And won't you be spotted? And don't the same consequences extend to those members of whatever party you may be concerned about being exposed to the repercussions you're talking about? How do we differentiate our argument in this regard to those other instances that happen so many times compared to a motion of no confidence? And yet you can't put a question to a minister hiding in somewhere. You must speak now, you must be seen.
Chief Justice, I'm going to try to answer the question.
Unless, of course, you ask it through a member of another party. You say, please, don't tell them it's me, but here is a question.
Yes, Chief Justice. I've represented a number of political parties over the years, and we know that those types of mechanisms are used from time to time. But let me answer. Let me answer it as a matter of principle, and I suppose my answer will be a non-answer. But that is this: last year in December, many citizens of the country were glued to their TV sets when an ad hoc committee was appointed by the National Assembly to investigate the question as to whether, under the Broadcasting Act, as to whether the board of the SABC should be removed. By that stage, of course, there was no board because they'd all been resigned or fired. And what was interesting was, in the US terms, the bipartisan nature of the debate. All the members of the committee, from the wide spectrum of the different political parties in Parliament, all played a role in trying to hold the SABC to account.
Can I interrupt you? Is the reason why you remember it so vividly that it is hard to come by a thing like that?
And that's the...
What are the 3 incidents, and only 3 can you cite?
No, the point, Chief Justice, I think...
Just by the way, I know it's a peripheral issue.
Yes, yes, I think, yeah. And what was interesting about the response, social media and general media, how wonderful it was to have a parliament that was working in this oversight role. Now, I understand the question, and this is why I'm going to give a non-answer, as to why couldn't it be like that in every case when Parliament are called to account, or call the executive to account, whether it be the DG or the minister or whatever. And the answer is, I don't know. But what I do know...
take you, I'm sorry I'm interrupted, doesn't it take you to the President's position though, which is, that becomes a possibility when you stand as in the US and other similarly structured democracies as a candidate. It is known. Mr. Kurtz is a candidate for Yeovil. Although being a member of a particular party, he's a candidate for that. Now you can speak boldly because you have your own constituency. But now that's not necessarily the case here, where you are on a list. And you can be knocked off or knocked in as and when circumstances seem to permit. So you really don't have a voice. Is that not where the President's point perhaps has more force to say, you've got to tell the party that we put you there. You didn't put yourself there. So when we say this is our position, you've got to follow suit.
The difficulty with that argument by the President is this. Once they are there, the moment they are there and they swear in, they're not there at the behest of the party, they're there at the behest of us, the citizens. And that's the full answer to the question. The moment they swear their oath of office, yes, they managed to get to be able to swear their oath of office by dint of being on the party list. But that party list evaporates the moment they have sworn it in. So that's the full answer.
But to the original question, I think you've given me an answer, and that is you have no answer.
I have no answer. And the reason I have no answer, the reason that we have no answer is because depending on the nature of that particular oversight mechanism, whichever it may be, it may or may not be a 102 type mechanism. But we know in this case, we have a clear 102 provision, which gives oversight in a particular way to a particular branch of government, that branch being the National Assembly, and they are told this is how you hold account. Those other questions, such as the ad hoc committee of, the Nkandla example. The Nkandla example was a good one, where this court found there was a failure to hold account. I know that there are other cases continuing that debate. I want to turn, Justice Zondo.
Go back to the answer you have just given to the Chief Justice, or maybe it was not an answer, but a statement you have just made. You say that once members of Parliament take the oath, then they cease to represent the party. They represent the people. How consistent is that with the position that I understand to be accepted, that the party can take you back, take you out of Parliament anytime if they are the ones who put you into Parliament? They can withdraw you anytime.
Justice Zondo, I'll try and answer the question, but before I answer it, I just want to qualify my answer to the Chief Justice directly. The answer that I gave, which was that once the oath is taken, the Member of Parliament is responsible to the citizens, applies at least in respect of Parliament's oversight role. It may not apply, and I don't say it does, and I'm making no submissions, in respect of an MP's responsibilities in other spheres of life as an MP. But certainly in respect of oversight, in respect of the executive, that principle applies. As far as the question as to whether or not a particular party may remove a member of Parliament from the list or from membership of the party if the member does not toe the party line is concerned, we would submit that the Constitution overrides that party principle. That principle as far as the parties are concerned. And it's not clear to us that were a party to discipline a member for not towing the line and voting in a particular way, in respect of motions of no conference, we limit our submissions to motions of no conference, whether that discipline would stand scrutiny.
Well, I wasn't having in mind only a situation where an MP is seen to have not towed the line by his or her party, but is the position not that a party may withdraw you from Parliament even if it's not for misconduct, or misconduct in a certain sense? Namely, for example, what if a party decided that, you know, in Parliament we have got too few women representing MPs. We need to increase the number. Therefore, we are going to withdraw some of our male MPs. So nothing to do with anything of not towing the line, but for that reason.
Yes, I'm not sure that that issue has come before this court yet. But as I understand the jurisprudence in the High Court and the SCA, that where a party withdraws a person who is a member of a legislature, whether it be local, provincial, or national, the party needs nevertheless to act rationally in a particular way. Issue hasn't arisen in this court, if I understand it correctly. But the question then would arise as to whether or not a particular member was let's call it replaced for particular reasons of policy or otherwise, and the rationality inquiry we would say be appropriate. I want to, before I turn to remedy, Chief Justice.
I'm sorry, Mr. Katz.
Yeah.
Mr. Katz, would I be wrong to say that the Constitution itself draws a line between arms of government and political parties? There's a clear distinction.
Yes.
When members of parliament act in the exercise of constitutional powers conferred on the National Assembly, they are not exercising those powers on behalf of political parties.
That's our submission, Justice Jafta, certainly in respect of 102 powers, yes.
What are the exceptions?
I don't, that's not, the point is, when a member of parliament exercises, when the National Assembly exercises power, it does so vis-a-vis the citizens and all citizens, irrespective of how the particular member became a member of that National Assembly, yes.
Can it be constitutionally permissible for any political party to act against a member of parliament for exercising their power as members of parliament in accordance with the constitution of the country, our supreme law?
We would suggest certainly not. Yes. Yes.
I think it's complicated. Anyway,
yes.
let's not
Chief Justice,
go there.
before
I just think it's complicated, but it's neither here nor there.
What all this court needs to decide, we would submit for this
Let's
case.
confine it to this case.
Motions of no conference, which is executive accountability.
Then it becomes easier.
Excuse me.
Then it becomes easier.
It becomes easier. I don't make submissions when it comes to voting for a particular bill or for other purposes, Justice Jafta, but for purpose of this issue that is before the court, the 102 purpose, we stand by our submissions. And just on that, we want to refer to a paragraph of, paragraph 17 of a judgment of this court from last year. It's called the Democratic Alliance versus the Speaker of the National Assembly. It's reported in 2016, volume 3, essay 487. And the last sentence of paragraph 17 of this court's judgment, and I'll just read it, needless to say, for Parliament properly, we want to emphasize the words properly, to exercise its oversight function over the executive, it must operate in an environment that guarantees members freedom from arrest, detention, prosecution, and importantly, or harassment of whatever nature. And that's what a secret ballot does. It provides that type of environment which gives those guarantees. Absent this freedom, this court said, Parliament may be cowed, with the result that oversight over the executive may be illusory. The sword of Damocles with no teeth. That's what we're concerned about. And I turn to remedy. Now, the UDM, in their remedy, they suggest in paragraph 3 and 4 how this court should deal with the issue. And we have a slight difference with them, and I say slight, and we set that slight difference out in the IFP's affidavit. And that is in particular on page 219 and 220 in paragraph 5. In paragraph 5.1, we explain that the declaratory relief which the UDM seek in paragraph 3 should be tweaked somewhat, and we add the words read, which is after the fifth word, the Constitution, read with the powers, privileges, and immunities of Parliament and Provincial Legislatures Act 2004. But in explaining that, we go on in the next paragraph to what we would say is a preferable reading of Prayer 4, where we ask for declarators, or we suggest declarators, that say, on a proper and constitutional interpretation of the NA rules, the rules require motions of no confidence in terms of Section 102 to be decided by secret ballot. And we would suggest that our paragraph 4 is neater and cleaner than 4.1 of the UDM's suggestion. And if the court is with us on that, we don't need 4.2.
Mr. Kurtz, but is it the rules that you would argue require, or is it the Constitution itself?
It's the Constitution that requires, but the rules properly interpreted require. And the rules need to be interpreted because of the constitutional injection into them.
No, are you not asking us to read into the rules something that would flow from the meaning you prefer for the constitutional provisions?
Yes, yes.
And if we're doing that, is that not where considerations of separation of powers come in? No. Are we not rewriting the rules of the National Assembly now?
No.
Is it not enough just to give a meaning? This is what the Constitution means. And leave it there.
If the court comes to the conclusion...
Why should we read things into the rules?
If the Constitution... Yes. Section 102 of the rules, which is on page 260, deals with the issue. Perhaps, let me answer it like this. If the court's minded to grant a declaration as to what the Constitution means, and the answer is, the court gives the answer that, that the Constitution requires motion of no conference in terms of Section 1 at all times, then the Speaker, the Speaker would then be obliged in every case to hold a secret ballot, and that would be the end of it. The court doesn't need to deal with the rules. That must be the answer.
Speaking for myself, at some stage, I would really need somebody to show me why the rules should be interpreted
I accept it.
As requiring of the Speaker to have the motion of no confidence held by secret ballot.
I accept that. I accept that.
Because whatever we do, we must know that Parliament still has its own power, its own authority, and it's on permissible, only on constitutionally permissible, under constitutionally permissible circumstances that you then begin to have the rule read the way it obviously does not read.
I accept that, Chief Justice. I accept that. Yeah. Chief Justice, the last question that I'm going to be forced to just touch upon with I think, a minute ago, is although the IFP is a respondent, we've made common cause with the applicant, and we would submit that were the court to come to the conclusion, either in the main that the Speaker has no discretion, that there's always a secret ballot, or alternatively we'd be entitled to costs of 2 counsel against those respondents.
But have you people are too many now?
You say the too many of us, Chief Justice? Well, we've only got 2. We've only got 2 counsel, Chief Justice. Look what we... Anyway, the point, we believe that we've been helpful, and we believe that we are the only litigant, and I don't say party because, of course, we're a political party, who put up the rules. And the second aspect is the IFP have been motivating and striving for a secret ballot for many years, and it's only a question of form or substance as to the question of whether we are truly a respondent or effectively an applicant.
I doubt if we should have regard to that, Mr. Katz. We must just interpret the Constitution. We can't now look at the history of a party and say, you know, this party has been doing this, it deserves some credit, and therefore, no. We must just look at the law and interpret it.
And if the court is with us, as we would suggest you interpret, as we would suggest that the law should be interpreted, then we'd be entitled to our court. As a piece of the court.
Thank you, Mr. Katz.
As a piece of the court.
Ms. Adams, we're going to take a lunch break for about 45 minutes. And it is that watch that we must look at. I think around 2:45, we should be back here. Thank you. The court will adjourn. All right, what you've been watching live is proceedings at the Constitutional Court, an attempt